Okay, I muted my speaker. I can't hear you now.
Good morning, and I am Judge Grace Uzomba. I'm the presiding judge of County Court at Law Number 2, and I welcome you to County Court at Law Number 2 on the 5th day of August, 2022. The court is in session by video conferencing using the Zoom application and made public by live streaming to YouTube and into the courtroom via the court TV. We are hybrid. I have people in the court, physically in the courtroom, as well as those who have elected to appear via Zoom and are being permitted to appear via Zoom. And as you know, with anything as far as permission is concerned, that permission can be revoked if the instructions are not followed. We will be on record with the official court reporter. I introduce you to Esther Delgado. She is the County Court 2's official court reporter. All persons in this session, as well as the public, are admonished to not and shall not record these proceedings. All counsel and persons in this session are reminded to exercise proper courtroom decorum and attire at all times. Further instructions for those that are appearing via Zoom. If you're in a vehicle, you cannot be in a vehicle, but you have two choices. You can get out of the vehicle, get to a quiet place so that you may participate from there. Or two, you can drive down to County Court at Law Number 2, located at 300 De La Rosa, San Antonio, Texas, 78205. We're located on the first floor of the Kadena Reeves Justice Center, and you can participate in person. Your name must be displayed to your first name and last name, not your phone's name, not your nickname, but your first name and last name, and not somebody else's name, please. So the person, for example, the person who's displaying their phone at Galaxy A12, you need to rename yourself to your real name. And first name and last name, please. Appearance. Folks in the courtroom have their video on, they're appearing, I can see them. So therefore, via Zoom, you need to have your video on, and also you need to be in good lighting so that I will be able to see your face clearly. If you are in a vehicle, your name is not displayed correctly, or your video is not on at the time I call on you, I will mark you as failure to appear. And I will give you an opportunity, though, to take care of that issue. That is to cure it, all right? And then I will recognize you and I will mark you as late. Posture, you need to sit up. The folks in the courtroom are sitting up, and so that you need to sit up. And I need to see your face. I need to see your face. Please take your device, place it on a flat surface, place yourself in the center of it. And so and then don't move, okay? There'll be, the Zoom has a chat feature. There'll be no chatting using the Zoom application without my specific permission. The only exception is if you need to step out, use the restroom, whatever, just let the bailiff know where you're going. The same thing with the folks in the courtroom. If you need to go ahead and step out, let the bailiff, that's Officer Dela Cruz, let him know where you're going. And so he keeps track of that for me, people coming in and out. There'll be no chewing gum, eating, drinking, vaping, or smoking in the Zoom. You cannot do it in the courtroom. You certainly cannot do it in Zoom. You cannot leave the courtroom or the Zoom final for the day without being specifically excused by myself or the court coordinator. Defendants, when you're leaving for the day, you either need to have one or two documents, a dismissal in your hand or a case setting form that tells you when you're going to be coming back to court. When your next court date is, anyway. For those of you in the courtroom, I'm going to call your name twice. Excuse me, for the courtroom and for a Zoom application. Defendants, I'm going to call your name 2 times. If I mispronounce it, please correct me so that I may make my best effort to to pronounce your name correctly. For those on Zoom, please unmute. Stay unmuted so I can acknowledge who your attorney is. And for those of you in the courtroom, please remain standing so that I would go ahead and check who your attorney is, that you have proper representation, that you have representation this morning. And if I see that you do not have an attorney, I will ask you whether you need to apply for a court-appointed attorney or if you need time to hire. And then I will deal with that matter right after I'm finished calling the docket. Attorneys, if you respond for your client, I still need to hear from the defendant, so I'll check both of you in. Attorneys, as you respond, if you let me know that you wish to confer with the ADA or consult with the court coordinator for a date, that would be very helpful so that we may be able to go ahead and move you quickly to get coordinating or conferring. Any violations of these instructions are subject to contempt of court. If I have any issues, I will need to go ahead and usually put you in a breakout room with the deputy, and deputy will go ahead and discuss with you as far as correcting the situation, assisting you in correcting it. Again, today is Friday. It is the 5th day of August, 2022, and I am looking for the following people. Gary Smith. Gary Smith.
John Young here for Gary Smith. I've had no contact with him. Judge, this is Ling Han, ADA. I believe that I've already given a dismissal because Mr. Smith is deceased.
That could be good reason of not being able to contact him. Okay. Thank you, ADA, and I do have the dismissal and counsel, if you have nothing further in this court, you're excused. Thank you.
I have one other case, Your Honor.
Samuel Narvaez. Samuel Narvaez. Mark that for failure to appear. Martin Ceballos. Martin Ceballos. Mark that failure to appear. Rachel Green Lees. Rachel Green Lees. Mark as failure to appear. Zoraya Waiter. Zoraya.
Your Honor, John
Renee?
Young here on Ms. Waiters. She is present on Zoom.
Roya, please unmute and respond. Roya, Zoraya Waiter. Counsel, you let me know when she's ready.
I don't know
Sarah,
why she-
Sarah Castillo. If they don't know how to use Zoom, they'll have time to go ahead and take a Zoom tutorial to be able to know how to use Zoom, or they can come to, you can come down to the courthouse, okay? We have ability to be able to have you go participate via Zoom if you are not
I'm
able
sorry,
to-
miss. I had to go. It wasn't letting me unmute it.
Sarah Castillo. Sarah Castillo. Mark that one as failure to appear. Marco Cabrera. Marco Antonio Cabrera.
I'm present, Your Honor.
Mark as failure to appear.
I'm present, Your Honor.
Oh, okay. All righty, sir. Is your attorney Ivan Barrera?
I see him on Zoom.
Sir, is your attorney Ivan Barrera?
Yes.
Thank you. Salvatore Capriato. Salvatore James Capriato.
Right here, Judge. I don't know where my attorney's at though.
Is your attorney Joanne Echo?
Yes, ma'am.
Thank you. We'll go ahead and wait for her. Thank you for being here.
All right.
Joel Lejean. Joel Torre Lejean.
I'm here.
Good morning, sir. Is your attorney Sharon Thorne?
Yes, ma'am.
All righty. We'll go ahead and wait for her. And you'll need to get in better lighting, sir. Rudolfo Perez. Rudolfo Perez. Go ahead and mark that failure to appear. Jasmine Rodriguez. Jasmine Nicole Rodriguez.
Here, Your Honor.
Good morning, Ms. Rodriguez. Is your attorney Jerry Kagan?
Yes, ma'am.
Thank you very much. We'll go ahead and wait for him. Thank you for being here. Sonia Rodriguez. Sonia H. Rodriguez. Mark that failure to appear. Luis Blanco. Luis Marcio Blanco.
Here.
I'm not going to recognize you at this time. You need to go ahead and fix the display of your name.
All right.
Monstrat Pimentel. Monstrat Pimentel. No, it's Montserrat.
I'm here, Your Honor.
Oh, good morning. Is your attorney David Cuellar?
Yes, Your Honor.
Okay, very good. Thank you for being here. We'll go ahead and wait for him. Jesus Macias. Jesus Macias. Desiree Tristan. Desiree Renee Tristan. Good morning, Ms. Tristan. Is your attorney Joe Stenberg? Very good. We'll go ahead and wait for him. Thank you for being here. Chance Gibson. Chance Aaron Gibson. Marcus failure to appear. Caitlin Levis or Levi's. Caitlin Levi's.
Here, Your Honor.
Judge, I'm
Good
present too. This is Baltazar Cerna. I represent Caitlin Levis. We got really late notice of this setting yesterday at around 5 weeks. When she was released from jail, she wasn't given a court date, but we're here. But we'd like to see if we get a 30-day reset because we barely got any discovery and don't know enough about the case yet. So we need a 30-day reset. You give us a 30-day reset.
Thank you, counsel. Do you need to confer with the ADAs? That's all I need to know at this time.
I'd like to see if I get a 30-day reset because I don't have enough information on the case yet, Judge,
All right.
to intelligently confer.
Okay. Thank you, counsel. I will deal with all those matters right after I finish calling my docket. Allow me to finish calling the docket.
Thank you.
Dick Dowell, Dick Basilio Dowell. Marcus failure to appear. Jenny Garza. Jenny Garza.
Yes, Judge, this is Ron Zimmerman. I represent Ms. Garza. I have been unable to contact her, left messages with her parents and her own cell phone number, as well as she was directed to be at Alpha House. I have left a message at Alpha House.
Counsel?
Yes, Judge.
Sorry to interrupt you, but you'll need to repeat all of that again right now. So I'll just mark her failure to appear.
Okay.
And I will be with you guys.
Okay.
Thank you. Just trying to get through the docket right now.
All
John Goodwin. John Jessup Goodwin.
Here, Your Honor.
Good morning, sir. Is your
Good morning.
attorney Greg DeMatis?
Yes, ma'am.
Okay, we'll go ahead and wait for him. Thank you for being here. George Luna. George Angel or Angel Luna. Mark that as failure to appear. Kenneth Cook. Kenneth Leonard Cook. Thank you very much, counsel, for being here. We'll go ahead and I see him in bond. Deputy, could you go ahead and check on that? I see him bonded out. Okay, he's not? Okay. Daniel Gonzalez. Daniel Gonzalez. Need to stand, sir. Is your attorney Julie Polak? You need to speak, sir. Okay, thank you. We'll go ahead and wait for her. Roy Dominguez, Roy Dominguez.
Here, Your Honor. Here, Your.
Alrighty, I'll need a video, so once you get that done, I'll recognize you.
Are we good?
All right, you need to go ahead and rename yourself. I need first name and last name, sir.
Roy Dominguez.
Yes, sir, I need that displayed. Rename yourself on the video. Look at
How
your
do I do
friend.
that? It says Roy Dominguez on my video.
Okay. Okay, Mr. Dominguez, my court report is saying that both of your names are displayed. It may be on my computer. So
Okay, okay.
is your attorney Julie Pollack? I
Yes,
see it
ma'am.
now. Okay, I had to go ahead and switch frames. Okay. Thank you, sir.
You're welcome.
We'll go ahead and wait for her. Now,
Yes,
and
ma'am.
in the courtroom, is there anybody that I have not called? Just the courtroom right now? Yes, ma'am. Okay. Yes, sir. Who's your attorney? Who? All right, thank you. We'll go ahead and wait first. Thank you. Now, in the Zoom, is there anybody that I have not recognized or have not called their name?
Your Honor, Zora Waiters has now got her Zoom up and is prepared to answer.
Okay, thank you, counsel. So let me look at her again. Zoraya Waiter.
Yes, ma'am.
Okay, alrighty, I've got you down, I've checked in, thank you very much. And I've got you marked
We
as
have
late.
conferred, Your Honor, on that, and we've requested trial
Counsel,
setting.
I'm just finishing up my docket at this time, and then I will go ahead and focus in on individual issues. Anyone else that I have not recognized or have not called their name, have not heard their name?
Yes, Your Honor.
Okay. Mr. Blanco, I see that your name, you're fixed, Luis Blanco.
Yes, ma'am.
Luis Blanco. Unmute and respond, Luis Blanco.
Yes, ma'am. I'm here.
Is your attorney Raymond Martinez?
Yes, ma'am.
Okay. Mr. Blanco, I need for you to go ahead and place your device on a flat surface and and there, you look good. Okay,
All
thank
right.
you very much, sir. We'll wait for your attorney. Anyone else that I have not recognized?
Yes, Your Honor.
Judge.
Call their name. All right, ma'am, you're not in proper court attire. I'll let you go ahead and get dressed, and then you can go ahead and appear in court. Anyone else?
Judge.
Sorry.
This
Excuse
is,
me, go ahead.
yeah, this is Marissa Aon. I'm here for Martin Ceballos. I was in another court.
Where Martin
Announcing-
Ceballos?
He is
Okay.
present on Zoom.
Alrighty, but Ceballos. Okay.
Your Honor.
Does he not recognize his name? Did I not pronounce it correctly?
I'm not sure.
Okay. All righty. Martin Ceballos,
Oh, presente.
you need to have your video on, sir.
Presente.
Okay, thank you. All righty,
Your Honor.
counsel, thank you much.
Thank you.
Your Honor, Willie Espinosa. My client is Willie Espinosa, and you didn't call that name.
Yes, sir. Thank you very much. Let me go ahead and add that on. Willie Espinosa?
He's not here yet, Your Honor. He's running late, but he's on the way and should be here in 10 or 15 minutes.
Thank you, counsel. Appreciate that. Anyone else?
Yes, ma'am.
Judge. Attorney Mark Rutledge for Dick Dow, Judge.
Yes, for,
Dick Dow,
okay,
defendant. He's outside the courtroom, Judge. They won't let him in without him. He didn't have a mask.
okay. Sir, please stand up. Is your name Dick Dowell? Okay. Alrighty. And thank you, counsel, Mark Rutledge. Thank you very much, sir. We got you checked in. In person. Anyone else?
Joe Stenberg or Desiree Tristan, Tristan.
You're Miss Tristan, no, Miss Tristan, okay. All right, good morning, sir. Your client did check in. She is in the courtroom.
Thank you.
All right, anyone else that I have not called their name, I have not been recognized?
Gary Kagan for Jasmine Rodriguez.
I believe Ms. Rodriguez checked in. Let me double check for you, sir. Yeah, your client checked in. Thank you, counsel. You're here. Anyone else?
Your Honor, Ivan Barrera here for Marco Cabrera. He's number 7 on the docket.
He checked in, I believe, so yes. Thank you, counsel. Anyone else?
Kiana Morgan.
Miss Morgan is key, Anna. And who's your attorney, please?
Paula.
Please say the first name again.
Julie.
Are you saying Dilly?
Julie. J-U-L.
Okay. And last name, is that Pollock?
Yes, ma'am.
Okay. All right, very good. We'll go ahead and wait for her. Thank you for being here. Anyone else that has not heard their name on Zoom? Anyone else who has not heard their name and or I have not recognized? Alrighty. That concludes the calling of the docket. Attorneys, ADAs, who's a conferring ADA?
Judge, I'm happy to confer, and Brett may not be available today, and if he is, he will be late coming in. So however you want to.
Okay.
um,
All right, attorneys, you've heard that. I have one ADA this morning. So we will go ahead and proceed, bearing that in mind. So attorneys who need to confer with the ADAs, please go ahead and either raise your hand or state your name so that we can get you moved in to go ahead and confer with the ADA.
Judge, may I approach now?
2 seconds. There's 2 seconds here. So there's no attorney that needs to confer with the ADAs.
Jerry Kagan, I don't mind conferring. We spoke once, but I'll speak to her again.
Let's go ahead and move Mr. Kagan, Attorney Kagan in with the ADA to confer.
And Joe Stenberg, please.
Attorney Stenberg, please.
Thank you.
Joe. And attorneys, if you're not in proper court attire, please go ahead and do so. Get in proper court attire. Tie and jacket, please. Okay. All righty. Okay, who's asking to approach?
John Young.
Yes, sir, as soon as you get in proper court attire. Sir.
Judge, may I also approach?
Attorney Ion, yes.
We're set for a plea this morning, and Miss Marina Luna let me know that the interpreter won't log on until 10:30.
Yes.
May my client and I come back at 10:30?
Yes.
Okay. Martín,
Sí.
si el intérprete no van a venir hasta las 10:30, ¿puedes regresar a las 10:30?
Oh, también iba a decir, pues aquí está. mi
Okay,
pareja, ella me
hang
puede
on 2
traducir.
seconds, hang on. I will put you in a break because if you start this conversation, counsel, you take up my Zoom and I can't do anything else. So I'll put you and your client in a breakout room if you need to do that, okay?
Yes, please, Judge.
Thank you. And that is Martin Ceballos. You have seen him? You got him? Yes. Okay, thank you.
Judge, may I approach now, Judge?
Who is H? Yes, sir. Who is that?
Walter Baltazar Cerna, Judge.
Okay, sir. You're conferring with the ADAs. When were you appointed on this case, sir?
I was at a point I was retained, Judge, but we've been calling over there trying to get a court date because when my client was released, it was a warrant at warrant that was issued at large on a fair to give info. And when she was released, there was no court date. We called several times and didn't know anything about the court date until we got the email last night or 5 o'clock yesterday from your court telling us that we had to appear today. So
Okay,
we're not ready today to confer. I need about 30 days to look over the discovery. We've gotten some of the discovery, not much of it. So if you give me 30 days, we'll be ready, Judge, and we'll confer with the state next time we appear.
okay. Sir, when were you retained?
Probably 60 days ago, Judge, but like I said, there's been no court date. They
Okay,
kept
but
telling me
sir,
the file wasn't ready.
So you would have received your e-discovery on that. Please go ahead and confer with the ADAs. Thank you.
Okay, well, there's not much on it, but you can send me over there.
Okay. All right. And Attorney White, we're just waiting for your client to arrive. Let me know. But Attorney White, I'm going to put you in with the ADA because to check on your the plea paperwork. Okay, sir?
Your Honor, we were entering the plea yesterday, and you postponed it to today because I hadn't finished filling out the personal data sheet, and I've done that now. So everything is
No,
ready.
I appreciate that, but again, if you would just go ahead and be able to check with the ADA on the plea paperwork, okay?
Yes, Your Honor.
All righty.
Senator John Young on Zora Waiter.
Yes, sir.
We have received an offer. My client has declined to accept it. We request a trial date.
Okay, sir, let me go ahead and put you in with the court coordinator. Set you up for a pretrial conference, and you can set that up right away, sir. We can accommodate you next Thursday, the 11th. Attorney Demarie or Demaris?
Good morning, Your Honor. I just need to confer with the state on John Goodwin. He is present.
Yes, sir.
Thank you, Judge. Yeah.
You got him? Okay. Attorney Kagan.
Hi, Judge. I have the same announcement as the other attorney. We're going to have to request a trial date.
Alrighty, sir.
I do have a vacation letter on file from August 10th until the 22nd, though.
You got it. Let me go ahead and get you in the room with the court coordinator for a pretrial conference date, sir. We can accommodate you as far as next week if you would like.
Okay.
For the pretrial conference, sir.
Okay.
Attorney Ron Zimmerman.
Yes, Judge. I am here on Jenny Garza. And I have been unable to contact her. Last I heard, she was over at Alpha House. I called Alpha House and went through the various messages that you needed to listen to. And I did leave a message with Alpha House for them to return my phone call so I could confirm whether Ms. Garza is still a resident or ever was a resident of Alpha House. I have not actually spoken directly with them. I also, in addition, left a message on her cell phone, as well as I contacted her mother's cell phone as well too. And the result of all that action is that I have not been in direct contact with Ms. Garza.
Okay. Council, do you need more time to continue efforts, or would I can go ahead and issue judge's warrant and we can notify you when she shows up?
Well, I would prefer not to have a warrant for her, Judge. So if we could reset to give more time to hopefully obtain some type of contact with Ms. Garza.
Okay, I can give you 5 days, sir, but it won't be a reset. I will issue a judge's warrant on the 12th. If you haven't been able to go ahead and get in touch with her, she'll need to come in and physically sign in with the court so we can get an up-to-date contact information with her and she knows where the court is. So I can give you to the 12th or the 15th. Which one would you prefer?
The 15th, Judge, if we could.
Okay.
Judge, I'm back. Walter Cerner, ready to approach when you're ready.
Okay, thank you. I'm just finishing up a note here. So counsel, she will need to come in by the 15th, on or before the 15th of August, 2020, in person to the court, check in with us, and then we may be able to go ahead and proceed. As a condition of her release, she was instructed to report to the Alpha House. We negotiated that. And so, but I'd be more than glad to give you a little bit more time to see if you can get a hold of her, okay?
I do appreciate the court's forbearance in this matter, Judge. And if I'm able to contact Ms. Garza, I will instruct her that she needs to appear in person in court to
check
continue.
in and, right. See you on the 15th, sir.
Right.
Thank you so much. Your excuse, unless you have something else in this court.
No, I do not have any other matter before the court today, Judge.
Thank you, sir. Your excuse. Have a
Thank
great
you.
weekend.
You have a good weekend too.
Judge, may I approach?
Yes, okay, give me 2 seconds, please.
Okay, thank you.
Who is asking to approach again, please?
Ms. Baltazar Sherna, Judge, I've conferred with the state.
Your cause
Uh,
number? Your cause number?
Let me give you my cause number, Judge. Sorry, it's Caitlin Levis, Judge, but it's, hold on. It is 683-966.
Righty, sir. See. Got it, sir. All right.
I'm going to tell you what the outcome.
Okay. Yes, okay.
683-966. I think it's number 18, Judge, on your page.
Yes, I've got it, Counsel. Thank you much. And she checked in. She's in via Zoom, right? Yes.
He is, Judge. And so we talked to the prosecutor. It's fair to stop and give information. I'm providing the insurance to Ling, and she's going to try and run down the victim in this case. We need about, if I could reset it for pretrial conference December 5th, we should have it all wrapped up and done hopefully by then.
Okay, Counsel. Thank you very much, Counsel. Let me go ahead and put you in with the court coordinator. You say you need
December 5th.
Alrighty. Okay. And that, if you check your calendar, sir, it is a
Monday.
It should be on a Thursday. Okay.
Okay. Well,
And
Thursday that
Counsel,
week. Yes.
Counsel, I put you in with the court coordinator. Please make sure to have your your client's email address for her so that she'll be able to go ahead and send out that case setting form. In fact, I'll put both of you and your client in there, sir.
And then
Okay?
after that week, we're excused, Judge?
Yes, sir. Absolutely. Have a great weekend. Thank you so
You
much.
too,
for your
Judge.
efforts.
Thank you. So I just leave now, Judge? I go to the breakout rooms? Yeah, okay, thank you.
Yes, sir. I sent you the invite. Okay. Attorney Stetson.
Good morning, Your Honor. I have one client today on the second page, line 15. Jesus Macias.
Yes, he did not. I don't think he answered the docket. Jesus Macias? He's where?
I've had prior contact with him.
Oh, hang
I
on.
sent him the link. I texted him, but he has not responded.
Okay. Oh, okay. Shall I up here? Okay. Alrighty. Okay. 682. Okay. Counsel, back in May, you indicated that he may have been in a hospital.
He was. That's why it was permitted to reset the case. But he does have a felony pending, but he has a different attorney. Ernest Acevedo is his attorney out of the 290th. And the state
Okay.
also indicated there's a third case that's sealed. It's awaiting filing. But I was going to ask for a felony pending reset, but he did not respond when I was texting him to log on.
Okay. So, Counsel, I can give you till the 15th of August to go ahead and try to get a hold of him, and he just needs to come in and check in with us. Okay?
Yes, Judge, I'd appreciate that. August 15, I will tell him to be in person. And is the in-person at 8:30 a.m.?
Yes, sir. On the 15th of August, I don't know, before the 15th of August, if he has not checked in with us, I will issue a judge's warrant. He'll be remanded without bond. If he is arrested, feel free to go ahead and approach me on that bond, okay? On that warrant, I'm sorry.
Yes. Yes, Judge, I appreciate that. Thank you. I'll get a hold of him and try to get him before the 15th. May I be excused?
Yes, sir. Oh. You got 2 seconds.
Your Honor, may I speak? This is Mike White.
Yes, hang on 2 seconds, please. Okay. Okay, Attorney White?
Yes, Your Honor. Yes, Your Honor, this is Mike White.
Yes. Yes.
Your Honor, I conferred with the ADA as you directed again, and everything is agreed and we're ready for a plea.
Okay, my problem is that the plea paperwork that I have has been canceled. And so I don't have access to the plea paperwork. So if they can resend the plea paperwork, I don't know what's going on. I don't know if that's how that happened.
Judge, this is ABA Han. The plea
Yes.
paperwork, the new plea paperwork that has been corrected was sent out to Mr. White and his client last night.
Okay, so have you received that, attorney? That's what I wanted you to discuss with the ADA's counsels, that where the plea paperwork is. And can you see whether you have that?
Well, I sent the personal data sheet yesterday afternoon. Again, a replacement personal data sheet had been sent to me because I hadn't completed the one that I had submitted. So I completed the second one and sent it in.
Attorney White, you just heard the ADA. She said she sent you plea paperwork. The plea paperwork that I had yesterday is canceled. I no longer have access to it. ADA has just said she sent you one last night. So let me go ahead and have her explain that to you, okay? Put you
All
back
right.
in that breakout room. Thank you.
All right.
John Young back from conferring with the court coordinator.
What's the case number, sir? Okay, I think I see it. It's on Zariah number 5 on the docket is 651-834.
Correct, Your Honor.
Okay. And I'll be right with you, counsel. I'm gonna go ahead and pull it, but there's other folks who had their hands raised up. So let me go ahead and go from left to right. Attorney Joanne Eckel.
Good morning, Judge. I have number 8 on your docket, Salvador Capriata, 669-623. We're here today to do a plea. Could the court give me some idea when they think the court will be ready to take the plea?
Okay. If you have someplace else to go, counsel, that's not a problem. Let me see if I have that paperwork. 669 623. Okay. Okay, counsel. I have the plea paperwork. And so just give me a couple minutes to attend to the other attorneys and then we'll go ahead and get started on pleas, okay?
Okay, do you think it'll be before 11, Judge? Because my client needs to leave. Okay, all right. Thank you, Judge. I'll wait.
Elizabeth, Attorney Elizabeth Settle.
Good morning, Judge. I have Chance Gibson on your docket. It's case number 683-836. And Judge, I believe he's been a failure to appear previously, and I believe a warrant was issued last month, and I haven't received any further information about him. So I think he's a fugitive, Judge, unless he showed up for docket call today.
No.
But I don't see him. He's not apparent there on the Zoom.
Thank you. I have him, Chance Gibson. I do have him as failing to answer the docket when I call the docket.
All right, Judge. And like I said, I believe there's already a warrant on him. out of your court.
Okay, there's just. Yes, and if you would, if you're able to go ahead and get a hold of him, please go, or if he is picked up, please approach me on that warrant, okay?
Yes, ma'am, I will.
All righty, thank you.
Thank you, may I be
And-
excused?
Yes, ma'am, thank you so much.
Thanks.
Attorney Jerry Kagan?
Thank you, Judge. We've agreed on December 1st. On Jasmine Rodriguez, I'm sorry.
So, what's the clause number again? Sorry.
677-394.
11? Sir, this is set for a plea today.
I don't know what to say about that, Judge. I don't know how it got set for a plea. I believe we've only had one other court setting. But my client has turned down the state's offer, and I have no recourse but to set it for trial. I'm reaching back into my memory. I think there was a visiting judge that day, so maybe there was some sort of error in setting it for a plea because I didn't even have the discovery back then. Or
Okay, Counsel, I'm just gonna go ahead and put you back in the breakout room with the, did your client checked in?
Yeah.
Breakout room with the court coordinator to go ahead and figure that out. And then what we'll do is, you and your client are excused. I'm gonna put both of you and your client there and you can be excused from there, okay, sir?
Okay, thank you.
All righty. Ms. Kagan and Jasmine Rodriguez. Okay. Make sure that she has her email address.
I've already given it to her.
Okay, thank you.
Thank you.
Attorney Kagan, you should have, if you look at the three dots to the right, you still should have access because you were in there talking with the court coordinator already, right?
Okay, yes. Let me see if I can figure this out. I see it. Thank you.
Excuse me a second. Attorney Ivan Barrera.
Judge, I have number 7 on the docket, Marco Cabrera, separate plea. Just want to let the court know we're ready on that when the court is ready.
Okay. Attorney Barrera, I'm going to put you back in with the state. I believe that they I still have a red file on it. Okay, Counsel?
Yes, Judge.
I put Ivan Barrera in with the state. Attorney Mark Rutledge.
Yes, Judge, it's for Dick Dow. He's in the courtroom now. He just let me know that he's completed the paperwork and it's been submitted, so we're ready for plea, Your Honor.
Okay, sir, I have the paperwork ready on Mr. Dowell. I have his file out. Okay.
You Judge.
Attorney Priest,
Good morning, Judge.
good morning, sir.
I had Robert Merchant, I believe he's number 8. And I was appointed after his last setting and I've been unable to reach him. I don't know if he's present.
What's the cause number, sir?
681667.
You said 681667, sir?
681667, Robert Merchant.
All right, I'm going to put you in a breakout room with the court coordinator to go ahead and, because there's an add-on, okay? So let me go ahead and put you in a breakout room with the court coordinator.
Okay.
Thank you, sir.
Thank you.
Attorney Cuellar,
Yes, Your Honor. Good morning.
good morning, sir.
I have Miss Pimentel, Monserrat Pimentel, number 14 on your docket. Case cause number 682157. We filled out paperwork. I believe we completed it successfully last night. So we're ready for a plea. If the court has-
I have it, sir, and I have you lined up. I have only one ADA, so we're trying to go ahead and get everybody lined up here. So I have just one ADA. The person who logged in as Victorious, okay. Attorney Cruz,
Good morning, Your Honor. I'm having some
morning.
device issues.
how
Thank
can I
you, Your
help
Honor.
you this morning? Do you need to talk to the ADAs?
Yes, Your Honor. It's an MTR, Mr. Blanco. He is logged on, and I just received the breakout room invitation.
Okay.
I know it's set for a contested, but I don't think it's going to be a contested, so we're going to work it out. Let me I will report back after conferring.
All right, thank you.
Your Honor.
Attorney James Hunt. Yes, sir. So could you check? I don't have his. I don't have his files up here. I don't have his files up there. Could you grab them? No. Thank you. Yes, sir. So do you need a setting for felony pending? Okay, but we need to give him a future court date. So we'll just give him one so that. Yes. Oh, okay, but he wasn't on the docket for today. Can I? Oh, okay. Please go ahead and bring his file up here and please can come back and give him instructions. And thanks. It's the felonies that are holding him in jail. Do you know dates the felonies are set for, sir? Okay. Where's he at? No, the felonies. sir, from there, you're excused. She'll go ahead and make sure she's in jail so that you can go ahead and get the case reset form, okay? All right. All right. Attorney Priest, I'm waiting for your file. Attorney Barrera,
Judge, I spoke to the state regarding the red file. That's correct, Judge. It is still a red file. I am comfortable with proceeding if the court is, or if not, we can reset this for a plea at a later time to give the state enough time to file it.
Counsel, can you look at your calendar and what date do you want it reset to?
Judge, we can do it for August 11th.
Okay. Would the 12th work for you, sir?
Judge, I have a vacation letter on file. I'll be out the next 2 weeks, starting on the 12th.
All right. What number was he on the docket, sir?
Number 7, Your Honor.
Thank you.
Your Honor, this is John Young. May I approach?
Yes, just give me 2 seconds, please. I'm just making a note here, please. Attorney Barrera, you, the reset for your reset for the 11th of August, 2022 for plea, you and your client are excused. Thank you.
Thank you, Judge. May I please be put in the breakout room with the court coordinator, please?
Yes.
Thank you, Judge.
Could you move him? Attorney Young?
Yes, Your Honor, the court coordinator asked me to come back and give you the trial announcement date of September 22nd on Zora Waiters. And also the trial date of September 26th.
What's that cost number, sir? Or number on the docket, or number 5, okay.
It would be excused, Your Honor.
Mhm. Alrighty. Sir, just hang on 2 seconds. I have one ADA. So this is set for a trial announcement today, sir. It was recall from the 28th for trial announcement. So we're going to do a trial announcement today, sir. Attorney Cruz, do I have my ADA back yet? Is she still in the breakout room? The ADA?
Judge, I'm here. On Ms.
Okay.
On Ms. Cruz's case, I've already submitted a motion to withdraw our MTR.
Okay. Alrighty, we'll go ahead and look at that in a minute. Alrighty, so You have cause number 651-834 pulled up.
Yes, Judge.
Okay. Let's get on record on cause number 651-834, State of Texas versus Zoraya Renique Waiter. Parties, please approach and identify who is before the court, starting with the state.
Ling Han for the state.
John Young for the defense.
As Zoraya Renique Waiter, please unmute
Yes,
and
ma'am.
respond.
Yes, ma'am.
Let the record reflect that the defendant is in the court session with her attorney. We're here for trial announcement on record. State, are we ready to proceed to trial on this matter?
Yes, Your Honor, we are.
Defense, are you ready to proceed to trial on this matter?
Yes, Your Honor.
We have a jury coming in on the 9th at 12:30. Counsel, I need for you and your client to be here by 11:30. If there's anything that we need to hear, motion in limine, let's hear that on Monday, okay? If there's anything at all that we need to discuss, we'll go ahead and impanel the jury Tuesday afternoon. So 11:30, I need for you and your client to be here for trial.
You said the 9th, which is Tuesday, correct?
Yes, sir. We get the jury, we're doing the scheduling of the jury because of everything that's going on. So I get the jury on Tuesday afternoons. They'll be seated at 12:30.
And will we start picking the jury then?
Yes, sir.
And that's, you want us here at 11:30 on Tuesday.
Right.
Thank you.
If there's anything that needs to, again, if we need to hear anything, arbitrate a motion in limine or anything of that nature, sir, then we need to go ahead and do that on Monday. So you can let the court coordinator know if there's anything that needs to be heard. We'll do that on Monday. Otherwise, we'll start picking the jury at 12:30.
Thank you, Your Honor. Are we excused now?
State, how long you think this trial may last?
I'm sorry, Judge. I was going off the assumption that we're doing trial announcements on September 22nd, like defense counsel had previously said, with trial to begin September 26th. Is that not correct?
That's not correct. This matter was set for trial announcement on the 28th of July. Because I was traveling and I didn't have a visiting judge, it was reset today for a trial announcement. Anything further on this? I asked you how long it might take. ADA, state?
Judge, I do not know.
Okay. All righty. See you guys on Tuesday, 11:30. Thank you.
Thank you,
You and your
Honor.
clients are excused. Let me go ahead and put you in the breakout room so we can get the case setting form so that your client is reminded that they need to be here on Tuesday, 11:30, okay?
Thank you, Your Honor.
Okay, we're off record. Put him and his client, Roya Waiter, in with the court coordinator. Okay, we have the interpreter here.
Good morning, Your Honor.
Good morning. Ms. Nero, thank you for being here. And we have Attorney,
I think it's my case, Your Honor.
yes, and give me that case number again, please.
Yes, that is,
Tobias, right?
yes, 628118.
I've got it. I've got it.
Excuse me, Judge, this is Joanne Akel. Could I be excused to come back from my plea at 11:25 or 30?
Yes.
All right, thank you, Judge. I'll see you then.
Thank you. All right. All of you that's here for a civil matter, I will go ahead and attend to your case as soon as we break at noon. I'll break for lunch at noon and I will deal with the civil matters at noon. You're free to stick around until then or leave and then come back the same Zoom session, okay? Thank you all so much. I just got your files.
Your Honor, can you hear me?
Yes.
This is Ms. Walker. I just want to make sure I'm understanding you correctly. I apologize. I have hypoglycemia and get confused. Did you say that I could leave but come back at 12?
Yes.
And the number, is it the same number that was given to me to come back here?
Yes.
Okay, thank you.
All right, thanks. Yes. Where are you?
She said it to you? To everybody. Excuse me, Your Honor.
Yes.
This is Helen Klonick for Marcelo Saldana. The defendant didn't show up to the hearing.
I'm going to handle all civil matters at noon, please. I have
At
to
noon.
take care of the criminal. So
Thank
at
you.
noon, thank you.
Thank you, Your Honor.
Okay, so come on back, same Zoom number. Thank you.
Thank you, Your Honor. So
I'm trying to find you people, still jumping around. Oh. Okay, Interpreter Nero, would you please be kind enough to give Mr. Martin Ceballos instructions regarding the interpretation feature and what we're going to do, please? Where's your client, Martin Ceballos? Okay,
Your Honor, I believe he was on here.
I see him. He has 11.
Yes.
We don't, wait, did you already turn it on? Oh, you gotta give us warning. Hold on, no, it's okay, leave it. I think she's able to communicate with him. No, you can't communicate with him? Take it off. Yeah, no, you.
Okay. Can you hear me, Judge?
Yes, yes,
All right.
thank you.
Yeah, I'll give the instructions before the interpretation function is set up. Señor Martín, may I address Mr. Ceballos?
Yes, please, proceed.
Okay. Señor Ceballos, ¿me escucha?
Sí.
Ok, yo voy a ser su intérprete en un momento cuando empiece su declaración. Si está usando un celular, le voy a pedir que en un momento van a activar la función de interpretación para que usted escuche todo en español y va a tener que tocar la pantalla de su teléfono. Va a haber 3 puntitos que dice más o more y elija interpretación, español y OK. OK, en un momento va a aparecer eso. To the attorneys, in this plea, you're going to have to select, when you see the globe on your screen, you're going to have to select English and to the judge as well. These are the same instructions for the judge. And if you can hear the interpreter in the background, you need to select, you need to mute original audio so you don't hear me in the background. Okay, so now whoever is activating the function, you can do it now. Thank you. Señor Ceballos, en un momento haga lo que le mencioné, ¿ok?
Sí, está bien.
Espérese un momentito, ahorita la van a activar.
Okay, go ahead and turn on the interpretation. No, she's gonna turn it on first. I know English, yes.
Sí. Ok. Ah, espera. Ok, está bien.
Thank you. Let us get on record on cause number.
Sí.
I apologize, State, I thought I had the file, the paperwork. Could you push it up for me again? Could you go ahead and push it? The State. State, could you go ahead and resend it?
For Mr. Cabrera,
Ceballos, 628118.
Judge, I think that Brett sent out that paperwork, so I don't have access to it.
Sorry, I was way too confident. I thought I had it all. I thought I had it.
Judge, it was sent July 1st. Let me see if I can help out with that.
Okay, all right, thanks. But let me take a look. Let's see. Oh.
Would the title of the documents help you, Judge?
I'm sorry, say again?
Would the title of the documents help out? Let me see if I can send it to you.
Oh, okay, it's not by case number. What is it? We're not on record. Got it. Let's get on record on cause number 628118, State of Texas versus Martin Villegas Ceballos. Parties, please approach and identify who's before the court, starting with the state.
Ling Han for the state.
Marissa Aon for defense.
Interpreter? Please raise your right hand. Do you solemnly swear to truly and accurately interpret from Spanish into English and from English into Spanish, so help you God? Thank you. And are you Martin Villegas or Villegas Ceballos?
Sí, soy yo.
The same that has been accused of driving while intoxicated with a BAC 0.15 or higher, alleged to have occurred on the 23rd day of November 2019 and classified as a Class A misdemeanor. Are you the same so accused?
Sí, soy yo.
Court is going to start sharing the court screen.
Sí.
Mr. Ceballos, can you see the court screen?
Sí, lo estoy mirando.
Counsel, can you see the court screen?
Yes, Your Honor.
And state?
Yes, Your Honor.
State on display is a document entitled State's Consent to Video Conferencing. Did you sign that document that's consenting to these proceedings by video conferencing?
It appears that Mr. Bosis did.
And state consents?
Yes, Your Honor.
Okay.
So I don't know what I just did. State's video conferencing consent is made part of the record. Defense on display is a document entitled Defendant's Consent to Video Conferencing. Mr. Ceballos, is this your signature where I am circling the cursor?
¿Está bien? Sí.
Did you sign this document that's consenting to plea by video conferencing?
Sí.
And counsel, with your signature on the same document, do you join your client in consenting to these proceedings by video conferencing?
Yes, Your Honor.
Defendant's video conferencing consent is made part of the record. Counsel, how long have you been representing Mr. Ceballos?
Since 2019.
And are we applying for probation? And if so, what type?
Yes, Your Honor, it's a deferred adjudication, I believe. And I have a copy of his personal information data sheet. I can email that to the court. It just wouldn't populate on when it was sent out, but I do have it filled out.
Please send it. Mr. Ceballos, I draw your attention to the document on display. It's entitled Application for Deferred Adjudication Community Supervision. It is a 2-page document. This is the first page, and this is the second page. I draw your attention to this area where I am about middle of the second page where I am circling the cursor. It states that you personally appeared before me today, albeit via Zoom. You are the defendant in this case. I have sworn you in, and under oath, you're going to tell me that your application for deferred adjudication community supervision and the document entitled personnel data sheet, which is going to be attached as an exhibit to your application, is true and correct. I am going to share with you your application, your personal data sheet. It is, all I need for you to do is identify for me if it is if there's any modifications that need to be made, whether we need to make correction or add some information in. Please keep in mind that if it is not completely filled in, that it cannot be true and correct.
Okay.
Counsel, have you sent the personnel data sheet?
I'm in the process of doing that, Your Honor.
Okay, we'll go ahead and suspend this, suspend the record for you to go ahead and do that. Let me attend to some attorneys.
Está bien.
Okay, Judge, it's been sent to Marina.
Thank you. Desiree, Tristan, are you still here? Okay. Please approach. I just want you to go ahead and look right there. You can look right there. All righty. I'm going to share the screen. All righty. Your attorney has worked hard for you and got this case dismissed. You have completed all of the conditions for dismissal.
Good.
So I'm going to sign it now. Oops. And then I'm going to send you to the back court to go ahead and get a copy of it, okay? To the chambers, and you get a copy of it. State, I'll need the copies from the defense to go ahead and get a copy of the completed evidence of the completed requirements. Okay.
Judge, defense counsel is not able to get those to me at the moment. He's in the CLE out of town.
Nothing going on. Marissa, are you there?
Yes.
Hey, this is Mike White. We finished our paperwork. I would like to tell the judge, but I don't know what's going on right now.
Oh, yeah, I think you got back on mute.
Can you hear me?
Yes.
Miss Attorney White, I suspended the record. I'm waiting for the paperwork from the attorney of the case that we're taking the plea on. After that, you are next. So state pull up cause number 679796 for Willie Espinoza. And then after that will be cause number 669623.
And Judge, Ms. Marina just let me know that you have the document of the personal data sheet with you on the bench now.
Yes, you mentioned that. I'm just waiting to receive it. Okay, thank you.
Judge, I'm here. It's hardly, I had to go to the restroom real quick, sorry.
Okay, well, at least we're lined up to go.
Attorney Rutledge, Attorney Cuellar, I have your documents pulled up. You and your clients can go to lunch, and I'll see you guys back at 1:30. That's when we're going to resume. I'm going to take care of two cases right after this plea. As you can understand the delay, it will be Attorney Michael White with Willie Espinoza and Cabriato, Salvador Cabriato, yes. Those are the two cases I'm gonna get in before I break for lunch at noon, okay?
Yes, Your Honor.
So the rest
1:30.
of you can go to lunch and be back at 1:30, please. 1:30, the court will resume.
Sure, thank you.
All right. Let's get back on record on cause number 628-118, State of Texas versus Martin Villegas Ceballos. At the time that we suspended the record, waiting for the personal data sheet. That data sheet, I have it. And so court is going to resume sharing the court's screen. Mr. Ceballos, you can still see the court screen?
Oh, sí.
Counsel, you can see the court screen?
Yes.
And state?
Yes, Your Honor.
Okay, at the time that we suspended the record, you're going to review your personal data sheet and see if there's any corrections that need to be made or information added. Allow me to go ahead and assist you. I don't have an address for the employer. I don't see an address for the second address of, yes, for the second reference. Will you be able to provide these information in when you come to provide your fingerprints?
Oh, está bien. No la di porque pues no sé dónde viven.
Okay.
Bueno, viven en departamentos, ¿me entiende? ¿Cómo?
As long as you need to go ahead and bring the information in when you come to provide your fingerprints. Yeah, you can discuss it with your attorney, okay?
Está bien.
Do you need, Mr. Ceballos, do you need to speak with your attorney to understand the consequences of your response to this statement? That the defendant understands and acknowledges that any untrue statement in your application for deferred adjudication community supervision or the exhibit, your personal data sheet, may be grounds for denial or revocation of any community supervision in this case?
Oh, ¿cómo, perdón?
Do you need to speak with your attorney? Do you need to speak with your attorney at this time to understand the consequences of your response to that statement?
Oh, sí.
We'll suspend the record so that you can speak with your attorney. Let me move you guys into a breakout room.
Está bien.
If you have not heard from your attorney, please, this is a good time for you to contact your attorney let them know that you'll be back at 1:30? Attorney Priest?
Yes, Judge, we'd already announced, I think I was just waiting to see if my client was present in court. I believe the court had asked for the file.
Your client, sir?
Robert Merchant,
Okay, sir.
and I have not had contact with him.
Sir, what are we doing on this case?
On
How are we
Mr.
going to dispose of it?
On Mr. Merchant's case, Your Honor?
Yes, sir. How are we going to dispose of it?
I do not know. I was appointed after his last setting. I have not had contact with him. And I don't believe he's present in court today.
No, he's not. You say you haven't had, but are you in contact with him now?
No, Your Honor.
Oh, okay.
I was appointed after the last setting on his reset form. I believe he appeared in person at his last setting, of which I wasn't appointed on yet. He put a phone number on the reset form. It was hard to read. I attempted to call him at that number, been unable to. I've called pretrial services and got 2 numbers from them, neither of which were good numbers. So I have not had any contact with him.
Okay. Counsel, can I give you some time to go ahead and get a hold of him, or would it be futile? Continue your efforts.
Whatever the court wants to do, Judge. If the court wants to give me more, obviously I'm reluctant to ask the court for something that would lead to a warrant for my client. Whatever the court wants to do, if the court would like me to continue trying to reach him, I would be more than happy to do so.
Counsel, I don't have a problem giving you if you think that, sorry, my cursor gets away from me. I don't mind giving you some time to be able to try to get hold of him, either the 15th or the 19th of August. Give you some time to go ahead and try to continue to get a hold of him.
Okay.
If you do get a hold of him, please let him know that all he has to do is come in and check in with the court, and we'll get him a new date set and all that kind of good stuff. We'll get good information on him. If not, on either the 15th or 19th, whichever you tell me, I will right now issue a judge's warrant and it'll be remanded without bond. But if you do get a hold of him between then and there, please, as long as that warrant is not executed, please approach me with it, and we'll go ahead and talk about that, okay?
I will, Judge. The 15th probably would work better for me.
All right, sir.
And if I get a hold of him beforehand, just let the court know.
Yes, sir. And he just needs to come in and sign in with us, so we'll get good information on him, good contact information for you.
I will do so. Thank you, Judge.
Thank you so much for being here for him. I appreciate your efforts.
Not a problem. May I be excused, Judge?
Absolutely. Have a great weekend.
You too.
Who's that? Yes. Wait a minute. Sorry, I was muted. Attorney Pollack?
Yes, Judge. Sorry, I was late. I did contact the coordinator. I was in the 175th. I've got 3 clients here today. First settings on all of them. I need to confer with the prosecutors.
Okay. Prosecutor's right in the middle of a plea. I have one prosecutor right now. So counsel, if I could ask you to come back at 1:30. We're going to break very shortly for lunch, and then we'll be back at 1:30.
All right. They might want me in the 144th
Well,
at 1:30, but I will certainly check in.
oh, yes, sir. Yes, ma'am. We'll go ahead and wait for you. Thank you.
All right. And my clients may be excused to come back at 1:30.
Yes, absolutely.
All right.
Ms.
Thank you.
Pollock, this is
Thank you.
ADA Han. If you would like to email me, that would work also.
Regarding all 3 of my cases.
Yes, if you would like to.
Okay, I'll do that. Thank you.
Attorney Rutledge, again, 1:30. So let me say it again. I'm going to take care of 3 cases, the one that we're doing now, and then one involving Attorney Michael White and Attorney Joanne Eckel. And that's all I'm going to try to accomplish within the next 30 minutes.
Okay, be back at 1:30.
Yes, please.
Thank you.
Thank you, sir.
Judge, my client Ray Dominguez has contacted me by chat, and he says he really needs to get back to work. He's been on Zoom since 9 a.m.
It's a court date, so he'll need to go ahead and be back at 1:30. Thank you. Okay. Do we have the interpretation working on? He needs to turn on the Spanish. Is that working?
She thinks when it's a court date, she's entitled to the whole day.
Okay. Okay. All right, can you see?
Sí.
Okay. All right. Attorney Demarius, will coming back, resuming at 1:30. I'm only handling 2 other cases at before noon, and then will resume at 1:30, sir. You and
Yes,
your
ma'am.
client are excused to go to lunch.
Okay, thanks, Judge. So as far as the felony pending, I emailed that to the coordinator. She wasn't giving us another date. I just came back to verify, that's all.
Okay, all righty. We'll see you at 1:30. If it's a felony pending and you've got that date, then you and your client, and she's reset it for felony pending. But I got a couple questions, but see you at 1:30. Just check in. We'll take care of that quickly, okay? Let me get this done. Getting back on record. On cause number 628-118, State of Texas versus Martin Villegas Ceballos. At the time that we suspended the record, the defendant had questions for his attorney. And so court is going to start sharing the course screen again. All right, Mr. Ceballos, you can see the court screen?
Sí, lo estoy mirando.
Okay, and counsel?
Yes, Your Honor, I can see it.
And so are we ready to proceed, defense?
Yes, Your Honor.
State, you ready to proceed?
State's ready.
Alrighty, so at the time that we suspended the record, I had asked the defendant if you wish to speak with you regarding this statement. Defendant, and he did, and so what is the response? Defendant, do you understand and acknowledge that any untrue statement in the application for deferred adjudication community supervision and or the exhibit, your personnel data sheet, may be grounds for denial or revocation of community supervision in this case? What is your response, Mr. Ceballos? Do you understand and do you acknowledge?
Sí, reconozco.
I will sign the document and make it part of the record. State, have you fulfilled your Brady and discovery requirement in this case?
Yes, Your Honor, we have.
And counsel, are you satisfied that the state has fulfilled its obligation to provide you discovery under Article 39.14 of the Texas Code of Criminal Procedure, as well as
Yes, Your
giving you full access to the state's files?
Yes, Your Honor.
State, is this matter subject to law enforcement disclosure? And if it is, has that been complied with?
It is subject to, and it has been complied with, Your Honor.
I will sign the discovery acknowledgement, making it part of the record. State, do you have any motions for the court's consideration at this time?
The state has a motion to amend the information. The state will be waiving, abandoning the enhancement and proceeding on obstruction.
State, did you file a written motion regarding waiver of the information, excuse me, altering and amending the information?
Mr. Bosa spread the paperwork, so I believe it probably has been as part of the plea paperwork, Your Honor.
Okay, let's see. So state, at this time, you have a written motion to alter and amend the information to add account 2.
Yes, Your Honor, I believe that's the intent.
Defense, what say you?
No objection to the amendment, Your Honor.
And defense, do you waive your 10 days to prepare?
Yes.
Mr. Ceballos, the information is the document that we use to bring you to court. In it, it contains the nature of the offense and the charges against you. Whenever that is altered, you get 10 days, whenever it's changed, you get 10 days to prepare. Your attorney has stated she wants to waive that 10 days to prepare. Do you join your attorney in waiving that 10 days to prepare?
Estoy de acuerdo con el abogado.
State's written motion to alter and amend the information with the defense without objection for the defense and defense waiving 10 days to prepare is granted and signed. The defense, now this is the amended information with count 2 added. State, do you have any other motions for the court's consideration at this time?
State has no other motions, Your Honor.
State, are you waiving the 0.15 enhancement as well as the count 1 and proceeding on count 2, class B misdemeanor?
Yes, Your Honor.
What say ye, defense?
No objection.
That motion is granted. State, anything else to any other motions or thing to admit?
No, Judge.
State, do you have an exhibit 1 that you wish the court to consider?
Yes, Judge.
Defense, state is presenting an exhibit 1 for admission. What say ye?
No objection.
Without objection, state's exhibit 1 is admitted. Mr. Ceballos, this is state's exhibit 1. It's the exhibit 1 is several documents. First one is waiver of objection to amendment of the information and rights, stipulation of facts and judicial confession. This is a 2-page document, this being the first page, and now this is the second page. The next document is motor vehicles in the household, whereby in this document, you have stated that you swear that the following motor vehicles are possessed or owned by you or a member of your family or household where you live. The address is not complete. It needs to be filled in correctly.
Your Honor, if I may,
But you-
I apologize for interrupting, but I just wanted to let the court know that page has also been submitted. I had submitted it to Marina, Miss Luna, and I believe it's on your bench as well. It wasn't, we were having trouble filling it out electronically, but it was filled out and scanned over.
Judge, it should be forwarded to you.
It can be completed when he comes in and completes it. I don't know what this is. Please, let me finish up with this, please. I don't know what this is, but we'll go ahead and it's an indication that maybe one vehicle is listed. You have signed that. Then this next document is a plea agreement, a plea bargain document. The next document is a waiver of appeal and post-conviction remedies. Next document is an oath whereby you state that, again, you are the person has appeared before the defendant in this plea. You have been sworn in, and under oath, you're stating all the facts stated in the above stipulations and plea agreement are true and correct, specifically including these documents. You have signed it, I will sign it, and here it indicates that you will plead guilty. I am going to go ahead and so order these documents to be entered into the record. State, do you have any other motions for the court's consideration?
No, Your Honor.
Defense, do you have any motions for the court's consideration?
Your Honor, I had spoken with Mr. Bosis regarding the plea agreement as far as the conditions, and he was not opposed to me approaching you regarding the ignition interlock.
Counsel, I will give you an opportunity to be able to address that issue. And when the time comes at sentencing, okay? But do you have any motions for the court's consideration at this time?
No motions at this time, Your Honor.
Mr. Ceballos, I draw your attention to the document on display entitled Defendant's Waiver of Constitutional Rights and Course Admonitions. This is a 2-page document. This is the first page, and then this is the second page. Is this your signature where I'm circling the cursor?
Sí.
Did you go over this document with your attorney?
Sí.
After reviewing this document with the attorney, did you voluntarily and freely sign it?
Sí.
Are you satisfied with the representation of the attorney?
Sí, lo estoy.
She has done a very good job for you. She has been able to go ahead and lower this from a DWI to a Class B misdemeanor to obstruction, and also a regular Class B misdemeanor. This document is also available in Spanish. Did she go over this document with you in Spanish? Here's the Spanish version.
Sí, lo reviso.
Okay. So do you understand the range of punishment that you?
Sí, lo entiendo.
Do you understand the range of punishment in this case now that you're pleading to?
Sí, entiendo.
Do you understand your constitutional rights?
Sí.
Do you, with that understanding, do you freely and voluntarily give up your constitutional rights?
No.
Are you a U.S. citizen? I'm sorry, say again?
No.
If you're not a U.S. citizen of the United States of America, you understand that a plea of guilty or no contest for the offenses charged may result in deportation, exclusion from admission to this country, or denial of naturalization under federal law.
Sí, lo entiendo.
You have discussed this with your attorney?
Sí,
You have been made aware of the potential consequences?
sí, me las explicó.
And now you are knowingly entering into this plea for this type of offense? Yes. So now you are going to knowingly enter into this plea for this type of offense.
Sí,
Counsel, have you reviewed the immigration consequences with your client?
Yes, Your Honor, and he did attempt to call multiple immigration attorneys, but was unsuccessful. He did try to call his previous immigration attorney, but they did not return his phone calls. But I did review with him the consequences.
Okay, counsel, at the time, and I believe that you had also mentioned this, that you wanted to give him an opportunity. We reset this from the 1st of July so that he would have an opportunity to consult with an immigration attorney.
Yes, that was the order of the court, to have him consult with an immigration attorney.
That is also what you stated, and that's what we reset it for at the time. So he has not been able to consult with an immigration attorney?
No, Your Honor, he has attempted to call multiple attorneys for it.
And in contacting multiple attorneys, they couldn't find one that would be able to consult with him?
That is what he's informed me. He's called multiple. They either didn't return his phone call, or they weren't able to speak with him. I had previously gone over the consequences that I understood, and Mr. Ceballos understood. It was the court's order that he also consult with an immigration attorney beyond the information that I had given him.
So I'm going to list you down as the attorney that he consulted with.
Yes, Your Honor.
And you have sufficient immigration background in order to have provided him his immigration, the consequences, potential consequences of this plea on his immigration status.
Your Honor, I do not practice immigration law, but I did provide him with all the information that I could and that I have from my years of experience in practicing criminal law. And I did provide him with names of attorneys that exclusively practice immigration. I do not know what their schedule is. I do know that he did attempt to contact them in order to fulfill the court's order.
All right. we're going to suspend this matter at this time. Court is now comfortable at this time in being able to take the plea of this defendant. Council, I'm sending you an invitation, and State, I'm sending you an invitation. Please join me there. Breakout room. Yes.
Sí.
I don't know if like what is this little hand mean? Your Honor, can you hear me?
I guess she's hearing that with the case. Without, no. Probably in a breakout room or something. I hope so, because we're after that.
Unmuted or unmuted?
You should have your invitations, excuse me. You should have your invitations to join the court coordinator. If you will go ahead and go there. Could you explain to Mr. Ceballos to go into to accept the invitation and go in to speak with the court coordinator interpreter? And please join them in there, okay? Thank you. And you're excused from there, please. Thank you.
Sí. So, no. Sí, solo que no tengo dice, solo tengo un, de este cuadro, dice entrar a sesión de grupo pequeño. Ok, está bien.
Chad?
Yes.
Well, they're about to hear my plea now. I'm waiting.
Yes, sir, I understand. And I am trying to get to your file.
Did you tell them where I was? Okay. Okay, Monday at 9 o'clock? Okay, all right.
Attorney White, are you ready to proceed? Attorney White, are you ready to proceed on your case? And the state is cause number 679796.
Yes, I'm sorry, I was muted. Yes, we're ready.
And your client is with you, sir?
Yes, he is. If I can put the camera on him, there he
Okay.
is.
Thank you. So go ahead and adjust it so I can see both of you, please.
All right. Get over close. Okay.
Let us get on record on cause number 679-796, State of Texas versus Willie Espinoza. Parties, please approach and identify who's before the court, starting with the state.
Karina Sanchez for the state judge. Good morning.
Michael White for the defense, Your Honor. Hmm? Not yet.
Are you Willie Espinoza?
Yes, Judge.
Are you the same that has been accused of failing to stop and give information over $200 alleged to have occurred on the 23rd day of February 2022 and classified as a Class B misdemeanor?
Yes, Judge.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing else but the truth, so help you God under pains and penalties of perjury?
Yes.
I'm going to, you can lower your right hand. I'm going to start sharing the court screen. On display is Mr. Espinoza, can you see the court screen?
Yes.
Counsel, can you see the court screen?
Yes, Judge.
Counsel, can you see the court screen?
I can, Your Honor.
You can?
Yes, I can see it, Your Honor.
Okay. State, can you see the court screen?
Yes, Your Honor.
And state on display is a document entitled State's Consent to Video Conferencing. Did you sign this document that's consenting to these proceedings by video conferencing?
Judge, ADA Link had signed this document, but I adopted as my own, as another ADA in the Bexar County office.
This State's consent to video conferencing is made part of the record. Defense, on display is a document entitled Defendant's Consent to Video Conferencing. Did Mr. Espinoza, is this your signature on this document where I'm circling the cursor?
Yes, ma'am.
Did you sign this document that's consenting to plea by video conferencing?
Yes, ma'am.
And counsel, with your signature on the same document, do you join your client in consenting to these proceedings by video conferencing?
I do, Your Honor.
Defendant's video conferencing consent is made part of the record. Counsel, how long have you been representing Mr. Espinoza?
Let's see, that has been,
Is it greater than 10 days, sir?
oh, yes, it's several months.
And we're applying for probation, and if so, what type?
I'm sorry, I didn't hear that, Your Honor.
Sir, are we applying for probation? Are we applying
That's
for
right.
judge-ordered community supervision probation?
Yes, we're applying for regular probation.
Mr. Espinoza, I draw your attention to the document entitled Application for Judge-Ordered Community Supervision Probation. This is a 2-page document. This is the first page, and then this is the second page. Where I am circling the cursor, it states that you personally appeared before me today and that you are the defendant in this case. I have sworn you in, and under oath, you're going to tell me that your application for judge order community supervision and the document entitled your personal data sheet, which is going to be attached as an exhibit to your application, is true and correct. I'm going to share with you your personal data sheet. Please tell me if there's any information that needs to be modified, with whether we need to go ahead and correct. make corrections, or add information in? Does anything need to be changed, sir?
No, ma'am.
All right, do you need to go ahead and speak to your attorney to understand the consequences of your response to this statement? Defendant understands and acknowledges that any untrue statement in your application or in the exhibit, your personal data sheet, may be grounds for denial or revocation of your community supervision in this case. Do you need to speak to your attorney?
No, ma'am.
And so what is your response? Do you understand and acknowledge?
Yes, I acknowledge.
I am going to sign the document, making it part of the record. State, have you fulfilled your discovery and Brady requirement in this case?
Yes, Your Honor.
Counsel, are you satisfied, defense, that the state has fulfilled their obligation to provide you discovery under Article 39.14 of the Texas Code of Criminal Procedure, as well as giving you full access to the state's files?
I am satisfied, Your Honor.
State, the law enforcement disclosure, is it applicable in this case? And if so, has it been complied with?
Yes, Your Honor, it is applicable in this case, considering the offense date is from February of this year, and that has been complied with.
Thank you, State. I will sign the discovery acknowledgement, making it part of the record. State, do you have any motions for the court's consideration?
No motions, Your Honor.
Defense, do you have any motions for the court's consideration?
No, Your Honor.
Mr. Espinoza, I draw your attention to the document on display, the defendant's waiver of constitutional rights and course admonitions. This is a 2-page document, this being the first page, this being the second page. Is this your signature where I'm circling the cursor, Mr. Espinoza?
Yes, Judge.
Did you go over this document with your attorney?
Yes, Judge.
After going over it with your attorney, did you freely and voluntarily sign this document?
Yes, Judge.
So with your signature and now your testimony, you're telling me that you understand everything in this 2-page document as it was reviewed and explained to you by your attorney.
Yes, Judge.
Are you satisfied with the representation of your attorney?
Yes, Judge.
He has done very well by you in being able to go ahead and resolve this matter for you today, bring it to a resolution. Did he explain to you the range of punishment in this case?
Yes, Judge.
And do you understand your constitutional rights?
Yes, ma'am.
With that understanding, do you freely and voluntarily give up your constitutional rights?
Yes, Judge.
Are you a U.S. citizen?
Yes, Judge.
I will approve your jury waiver. I am going to sign it, make it part of the record. You will no longer be able to have a trial in this case. Counsel, do you believe that your client is competent to enter into a plea?
I do, Your Honor.
With the information, were you able to apprise this defendant of the nature of the offense and the charges against him?
Yes, Your Honor.
Do you and this defendant waive the formal reading of the information?
We do.
And state, what is the punishment recommendation in this case?
Judge, the recommendation is a $300 fine with court costs, 180 days in the Bexar County Jail, probated over 8 months of probation, 40 hours of community service, that's 40, a driver's safety course, and restitution, if any, to be determined by CSCD, payable to George, Jorge, Vasquez, VAZQUEZ.
Counsel, is that your understanding of the state's punishment recommendation in this case?
It is, Your Honor, but it's also understood that if he's not satisfied with the proof on the restitution, that he should have the right to have a hearing on that if he requests it.
Okay. State?
Judge, I would just request that we have a little bit more clarification. If the restitution amount exceeds X amount, we will come back for a hearing. Just a little bit more clarification for the state.
Defense?
Yeah, I don't know. Well, if they have that figure, yes, I guess so, but I thought they didn't have that figure of what they estimated to be the restitution.
Anything further on this, on the discussion regarding restitution, State?
Judge, at this time, we don't have that number, but defense is more than welcome to approach the court if the number is not agreeable on both sides at that time.
Defense, anything further on the matter of restitution? Are you reserving your right to have a restitution hearing?
Right.
Did you say no?
No, I said yes.
Oh, okay. So do you have anything further?
No, Your Honor. No, we have nothing further on that then.
Alrighty. Other than that, counsel, is that your understanding of the state's punishment recommendation and to the court?
It is, Your Honor.
And Mr. Espinoza, is that your understanding of what your attorney has worked out with the state on your behalf in order to be able to resolve this matter for you today?
Yes, Judge.
So with that understanding, how do you wish to plead? Guilty, not guilty, or no contest?
No contest.
No contest?
Sir, do you understand that even though you plead no contest, I can still find you guilty?
Right.
Yes, ma'am.
And you still wish to proceed?
Yes, ma'am.
After discussing with your attorney, you're entering a plea of no contest, and thereby you're telling this court that you do not want to fight any of the charges in this case.
Right.
Yes, Judge.
And after discussing with your attorney, you believe that your plea of no contest is in your best interest.
Yes, Judge.
I will accept your plea of no contest, finding that it is intelligently and freely made, and that you are competent to enter into such a plea.
Yes, Judge.
Counsel, what, if anything, on behalf of your client, and why I should consider this plea?
Yeah, I just ask you consider that plea.
What is it bouncing back and forth like this? Okay. Counsel, is there any legal reason why sentencing cannot be imposed today?
No, Your Honor.
State, do you have any objections to this defendant being referred to the Bear County Gives Back program for the community supervision, a community service restitution?
No objections from the state, Judge.
Counsel, are you familiar with that program?
I didn't recognize it. Could you say it again? Maybe I didn't hear it all or something.
Bear County Gives Back program.
Well, no, but we have no objections to it.
The CLO is here, and I'll put you in the breakout room with her, and she will be able to go ahead and explain that to you and see if your client is eligible for the program.
I see. All right.
There being no legal reason to go ahead and for sentencing to not impose a sentence, the court is going to find you guilty, Mr. Espinoza, and I'm going to sentence you to 180 days in Bexar County Jail. I will suspend that sentence and probate it over the next 8 months for failure to stop and give information over $200. You will be supervised by the Community Supervision and Corrections Department on behalf of this court with the following conditions: $300 fine plus court costs, 40 hours of community service restitution. I'm going to refer you to the Bexar County Gives Back program to satisfy that requirement. You can participate in it if you wish, once you're found eligible, if you're eligible for it. And if you're not, or do not wish to go ahead and participate, you are still responsible for that 40 hours of community service restitution. Driver safety course will be completed within the first 60 days of your community supervision. Restitution, if any, to be determined by the Community Supervision and Corrections Department to a Jorge Vasquez. The defense does reserve its right to a hearing on the restitution amount, if any. That will be set. The defense will need to file a motion and we'll go ahead and set that for a hearing. And I'm going to set your supervision fee at $40. State, did I cover everything for you?
Yes, Your Honor, you did.
Counsel, anything further on this matter?
No, Your Honor.
Mr. Espinoza, you'll need to come down to the courthouse to provide your fingerprints. When will you be able to do that? Monday, Tuesday, or Wednesday of next week? What day?
Wednesday.
Mr. Espinoza, with regarding the trial court certification of defendant's right to appeal, this has been a plea bargain case, and you will, the court is going to certify that you have no right to appeal. You will get a copy of this when you come down on Wednesday to provide us your fingerprints, and that is Wednesday, the 10th of August. You'll be coming down to County Court at Law Number 2, located at 300 De La Rosa, San Antonio, Texas, 78205. We are located on the first floor of the Cadena Reese Justice Center. And sir, you will be coming between the hours of 2 p.m. but before 4:30 p.m. If you do not show up on Wednesday, on the 10th of August, 2022, sir, a warrant will be issued for your arrest. Do you understand that?
Yes, Judge.
Okay, at this time, I'm going to place you in the breakout room with the court liaison officer. Sir, I wish you the best of luck with this. And we're looking for your success on probation. And remember to keep in communication with your probation officer if there's anything that may interfere with your successful completion of probation, okay?
Yes, ma'am.
Alrighty, we're off record on this matter. Thank you all very much.
Thank you, Your Honor.
Thank you, Judge.
Yes, sir. Court is going to stop sharing.
Excuse then.
I will go, sir, you can be excused from after you guys finish talking with the probation officer. I'm going to move you in there right now, sir. Okay?
All right, thank you.
Alrighty. Let's get on record on cause number 669623. State of Texas versus Salvador James Capriato. Parties, please approach and identify who's before the court, starting with the state.
Karina Sanchez for the state.
Joanne Akel for the defendant.
Are you Salvador James Capriato?
Yes, ma'am.
The same that has been accused with tampering with government record alleged to have occurred on the 14th day of September 2021 and classified as a Class B misdemeanor. Are you the same so accused?
Yes, Judge.
Sir, I need for you to go ahead and sit up, and whatever you're doing with your hair, please, you need to go ahead and place your device on a flat surface and place yourself in the center of it as you are now. Very nice. Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing else but the truth under pains and penalties of perjury? So help you God.
Yes, ma'am.
Thank you. May you go ahead and lower your right hand. Court is going to start sharing the court screen. Mr. Capriato, can you see the court screen?
Yes, ma'am.
Counsel, can you see the court screen?
Defense can, Your Honor.
And state, can you see the court screen?
Yes, Your Honor.
State, on display is a document entitled State's Consent to Video Conferencing. Did you sign this document that's consenting to these proceedings by video conferencing?
Your Honor, ADA Ling did sign these documents and I adopt her signature as my own. Yes, the state has signed.
Thank you. The state's video conferencing consent is made part of the record. Defense, on display is a document entitled Defendant's Consent to Video Conferencing. Mr. Capriato, is this your signature where I am circling the cursor?
Yes, ma'am.
Sir, did you sign this document that's consenting to plea by video conferencing?
Yes, ma'am.
Counsel, with your signature on the same document, do you join your client in consenting to these proceedings by video conferencing?
Yes, Judge.
The defendant's video conferencing consent is made part of the record. Counsel, how long have you been representing Mr. Capriato?
More than 10 days, Judge.
Are we applying for probation, and if so, what type?
We're applying for deferred probation, Judge.
Mr. Capriato, I draw your attention to the document on display. It's entitled Application for Deferred Adjudication Community Supervision. This is a 2-page document. This is the first page. This is the second page. On here, and draw your attention further to where I'm circling the cursor where it says that you personally appeared before me. You are the defendant in this case, and I have sworn you in and under oath, you're going to state that your application for deferred adjudication community supervision and the document entitled Personnel Data Sheet, which is going to be attached as an exhibit to your application, is true and correct. I'm going to share with you your personal data sheet. Keep in mind that if it's not completely filled in, then it cannot be true and correct. And all I need for you to do is identify for me any missing information that we need to go ahead and fill in or make any corrections to. Do you have any? Sir, do you have anything to identify?
Ma'am. No,
Do you
ma'am.
need to-
You want me to sign right there where the thing is?
Sir, do you need to speak with your attorney? Sign what, sir?
Oh, I seen like a little red star by that one thing. Never mind. I guess not.
Oh, okay. Sir, do you need to speak with your attorney?
Oh, no, ma'am.
In response to understand the consequences of the response to this statement. Defendant understands and acknowledges that any untrue statement in your application or your personal data sheet, the exhibit, may be grounds for denial of revocation or community supervision in this case? You
No,
need to
ma'am.
speak to your attorney.
No, ma'am.
And so do you understand and so acknowledge?
Yes, ma'am.
I will sign the document, making it part of the record. State, have you fulfilled your discovery and Brady requirement in this case?
Yes, Your Honor.
Counsel, defense, are you satisfied that the state has fulfilled its obligation to provide you discovery under Article 39.14 of the Texas Code of Criminal Procedure and giving you full access to the state's files?
As far as I can tell, yes, Your Honor.
State, is the law enforcement disclosure applicable to this case? And if it is, has that been complied with?
Yes, Judge. This case is applicable for that. This offense date is September 14th, 2021, and the state has complied.
I will sign the discovery acknowledgement, making it part of the record. State, do you have any motions for the court's consideration at this time?
No, Your Honor, no motions.
Defense, do you have any motions for the court's consideration?
No, Judge.
Mr. Capriato, I draw your attention to the document on display. It's entitled Defendant's Waiver of Constitutional Rights and Courts Admonishments. Sir, this is a two-page document. This is the first page. And then this is the second page. Is this your signature where I am circling the cursor, Mr. Capriato?
Yes, ma'am.
Did you review this document with your attorney?
Yes, ma'am.
After reviewing it with your attorney, did you freely and voluntarily sign it?
Yes, ma'am.
With your signature here and your testimony now, you're telling me that you understand everything in this two-page document as it was reviewed and explained to you by your attorney?
Yes, ma'am, I do.
And you satisfied with the representation of your attorney?
Yes, ma'am.
And you see, your attorney has worked hard for you to be able to resolve this matter today. Did she explain to you as far as the range of punishment in this case? And you understood it?
Yes, ma'am.
And you understand your constitutional rights?
Yes, ma'am, I do.
With that understanding, sir, how do you freely and voluntarily give up your constitutional rights?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
I will approve your jury waiver in this matter, and I will sign the document, and you will no longer be able to have a trial in this case, as I have made a record of it. Counsel, do you believe that your client is competent to enter into a plea today?
Yes, Judge.
With the information, were you able to apprise this defendant of the nature of the offense and charges against him?
Yes, Judge.
And do you and this defendant waive the formal reading of the information?
Yes, Judge.
State, what is your punishment recommendation in this case?
Your Honor, the state's recommendation is a $0 fine with court costs, 6 months deferred adjudication. One of the conditions is for the defendant to obtain a driver's license or submit a non-driving affidavit.
You say 0 fine plus court costs, 6 months deferred?
Yes, Your Honor.
Counsel, Counsel, is that your understanding of the state's punishment recommendation in this case?
It is, Judge.
And Mrs. Capriato, is that your understanding of what your attorney has worked out with the state on your behalf in order to be able to resolve this matter for you today or dispose of this matter?
Yes, ma'am.
With that understanding, how do you wish to plead? Guilty, not guilty, or no contest?
Guilty.
Judge, may I correct that? He's entering a plea of no contest, Judge.
Oh, okay. Sorry about that. I don't know. Yeah.
Counsel, he stated that he just doesn't know.
I think he does, Judge. He just,
I know. It came out wrong. You know what I mean? I'm not used to all the court stuff, so I kind of just, you know what I mean?
No, I don't know what you mean, sir.
No, I understand fully. No contest.
You understand what?
No contest, which means I'm not putting up a fight.
Correct.
Yeah.
You understand?
Yes.
So you understand that even though you plead no contest, that I can still find you guilty?
Yes, ma'am.
And therefore you still wish to continue?
Yes, ma'am.
So with your plea of no contest, after discussing with your attorney, you're telling me that you do not wish to fight any of the charges in this case?
No, ma'am.
Yeah. You just told me that you did not want to go ahead and fight anything. So is that what you're saying, that you do not want to fight the charges in this case?
Yes, ma'am.
And then you believe that your plea of no contest is in your best interest?
Yes, ma'am.
I will go ahead and accept your plea of no contest, finding that it is intelligently and freely made and that you are competent to do so and to enter into such a plea. Counsel, what, if anything, on behalf of your client and why I should consider this plea?
Judge, I would just say in the interest of time, I know the court has many things on their docket that we would just ask the court to follow the plea bargain.
Mm-hmm. State, when do you wish for that valid Texas driver license to be produced?
Your Honor, as long as it is produced within the probationary term amount, which is 6 months, that would be sufficient for the state.
What happened with the driver's license in this case? You do not have a driver's license?
No, ma'am.
What is preventing you from having a driver's license, sir?
I think just over the years, a lot of tickets and stuff like that. Like I've been pulled over quite a few times, and just over time, just racked up stuff that I think I did away with the surcharges though, right? So
Sir,
I haven't tried. Yes, ma'am.
I'll give you 2 months to get your driver's license.
Okay, that'll work.
I will also, okay. Counsel, is there any legal reason why this matter cannot be disposed of today?
None that I'm aware of, Judge.
Alrighty. Mr. Capriato, I am going to, although there's sufficient evidence to find you guilty in this case, I am going to withhold my finding of guilt, and I'm going to place you on 6 months of deferred adjudication probation for tampering with a government record. On behalf of the court, you're going to be supervised by the Community Supervision and Corrections Department with these following conditions. $0 fine plus court costs. A life skills course, 40 hours of community service restitution. I will require for you to provide me a no driving affidavit within 10 calendar days. And you will have produce to your community supervision officer a Texas driver's license within the next 2 months. State, did I cover everything for, I'm setting your supervision fee at $45. State, did I cover everything for you?
Yes, Your Honor.
Counsel, anything further on this matter?
Judge, I guess I would just ask the court if the court would consider giving Mr. Capriati 24 hours of community service, since this is a Class B misdemeanor.
I'll be, at your behest, counsel, I'll be glad to go ahead and lower it to 30 hours.
Thank you, Judge.
Yes, sir. Yes, ma'am. Anything further?
Nothing further, Judge. May I be excused?
Mr. Capriato, with regard to the trial court certification of defendant's right to appeal, this has been a plea bargain case.
Yes, ma'am.
And I am going to certify that you have no right to appeal. You'll be able to go ahead and pick up this document, a copy of your the trial court certification of defendant's right to appeal, when you come down to provide us your fingerprints. When would you be able to do that? Monday, Tuesday, or Wednesday next week, sir?
I could do it Monday. And ma'am,
Sir, you'll be coming down to county court at law number.
Yeah.
You'll be coming down to county court at law number 2, located at 300 Dolorosa, San Antonio, Texas, 78205. We're on the first floor of the Cadena Reese Justice Center. You'll need to come between the hours of 2 p.m. and before 4:30 p.m. to the courthouse. On Monday, that you've selected, and that is the 8th of August, 2022. Sir, understand that if you do not show up on Monday, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am. And what was the you said 10 days to get what now? What was that again?
I'll put you in a breakout room with your attorney so she can go ahead and explain that all to you, okay, sir? But it's no driving affidavit.
Oh, okay, yeah, no, all right.
All right, Mr. Capriato, we look forward to you going ahead for your successful completion of probation. You understand what your requirements are. I'm going to place you in a breakout room with your attorney to go over any questions at all. And regarding the life skills, your probation will be able to give you guidance and all of that. Okay?
Okay, thank you, ma'am.
All righty, well, thank you very much. Counsel, you and your client can be excused from after you are finished discussing, all right?
Thank you, Judge.
Thank you. Have a great weekend.
You too.
Thank you. Attorney Hicks will be back at Attorney ADA Sanchez. Thank you so much for going ahead and jumping in, and we'll see you guys at 1:30 coming back, and court will resume at 1:30. Attorney Hicks, I will see you at 1:30. Okay?
Thank you, ma'am.
Thank you, Judge.
I have person by the whose name is marked as L. Please rename yourself to show your first name and last name. Okay? Alrighty. I have cause number 2022 CV 02455. And I believe this is the matter of Marcelo Sadania versus Julie Crone. Who is answering to that?
My name is Helen Klonick, and I'm the agent for Mr. Saldana.
You're on the plaintiff side?
Yes, ma'am.
Okay, and are you an attorney?
I have a limited power of attorney for him, sir. I'm sorry.
For Marcelo Sadania.
Yes, ma'am.
And where is he?
He is at home. He's an elderly man, 90 years old. And right now he had symptoms and he wasn't sure if the daughter was not sure if she could get him out, the condition he's in. So he was not able to come to our office, or we were able to go to his house to take him the computer to be on today due to his health.
Okay. They're not able to go ahead and zoom in. They don't have the.
No, they didn't have the capability of doing so. And we
Okay.
could not be there because we do not know if he's got COVID or not.
Okay. And who's on the other side? Julia Crone? Julia Crone.
She did not answer this morning either, ma'am.
Okay, all righty, give her a call. And mark you guys as conferring right now to go ahead and see if you can get a hold of her, okay?
Okay, thank you.
Thank you. And how much time have you announced on this?
5 minutes, ma'am.
And
This
it's
is
5 minutes?
a motion for judgment for an eviction she appealed on.
For what?
An eviction.
Okay. I have, thank you. You can go ahead and proceed to go call her, okay?
Thank you.
Alrighty. Again, the person who is displayed, ma'am, you have something wrapped around your head, a tie around your head. Could you please rename yourself? All I'm showing is
Can you
L.
hear me?
Yes, please rename yourself so I know who you are, okay?
How
Cause
do I
number
do that?
2022 CV 02439. This is a matter of Daniela Walker versus Regency Property Management.
That's me, Your Honor. I don't know if you can hear me.
Okay, let me go ahead and let you, give you a chance to go ahead and fix up your name, and then I'll be right back with you, okay?
I have no idea how to do that.
Then take a Zoom tutorial. You
Okay.
I advised you of that earlier this morning when you first talked about that, okay? So
I did not hear Your Honor.
YouTube has Zoom tutorials, how to do that, okay? All you have to do is rename yourself. Thank you. Clause number 2022 CV 02440. This is a matter of, again, Danielle Walker versus Regency Property Management. We're still waiting on that one. I have clause number 2022 CV 02441. Okay. All these three cases are Regency. Who's on the opposite side of who's Regency Property? Who is Danielle Walker?
I am, Your Honor.
Lad Stricter?
Yes, Judge. Good afternoon.
Yeah.
Yes, I'm
Good
the
afternoon.
counsel for the defendant, Regency Property Management.
You are the defendant.
Yes, Judge.
Okay. Are you an attorney?
Yes, yes, ma'am.
Okay. Tony Spangler? Law offices of Tony Sprangler? So, counsel, you have 3 different cases.
Yes, Your Honor.
Attorney Stricker?
Yes, Your Honor, that is correct. Yes, there
How do
are.
you say your last name correctly, please, sir?
Yeah, I think you were correct. It's Stricker. Most people say
Okay.
Striker, but I don't mind Striker. Sounds good as well.
Okay.
But yes,
All right.
Judge, you are-
Why do we have 3 different causes?
Yes, Judge. So yeah, you are correct. This case is about a number of appeals that Ms. Walker has filed in the JP court, and I don't know why they were separated in 3 separate cause numbers, Your Honor. Part of what I want to get into today with you, Judge, is trying to consolidate these 3 cause numbers into one, just so the court can navigate this matter more efficiently, because they involve, I believe, the same facts, definitely the same parties. So there's no reason why it should be in 3 separate causes.
So these 3 different cause numbers are, I see the same parties, but you're saying it's the same issues?
I believe so, Judge, but I mean, part of what I wanted to bring to you with this hearing, Your Honor, is I don't really know exactly what all of the claims are, because, or at least the factual bases for these claims, because Ms. Walker had some claims she had filed in the JP court back in April. My client was not served with those claims. The judge of the JP court just dismissed those claims for lack of jurisdiction. And then Ms. Walker filed appeals about 6 weeks ago for those claims. And that's at which point my client received a notice of those claims that were appealed to your court. However, what's interesting is that there'll be one cause number that's an appeal, and the notice says 5 different claims like embezzlement, breach of contract, and so on. But the appeal of the claim from the JP court is a repair and remedy claim. So it's hard to ascertain what facts are relevant to these new claims that have been asserted by Ms. Walker on this appeal. So, Your Honor, I mean, part of what this hearing is about, during the docket call this morning, Judge Vara instructed me to come before your court to discuss resetting this trial date so we can organize these claims into one cause number, and also give us a chance to figure out what the factual bases are for these claims. And
She did not say that.
well, that was the basis I provided to that judge about why we should reset the hearing, Your Honor. The judge is not, that's correct. The judge didn't say what should we reset for those reasons. But just she instructed me to let you know of my basis.
She didn't say that either, sir.
Sure.
Ms. Walker, this is how it happens, okay?
Yes, ma'am.
I'm going to give you an opportunity. Now that you have changed your name, thank you very much, and renamed yourself. I know who you are.
I apologize about that.
No, you're fine. You're fine. It just one of those things, how it works. So what we're going to do is while I was waiting for you, I was letting the attorney kind of give me a background on all of this, okay? So I'm not listening to any argument on this right now, but I'm going to give you an opportunity to speak. Do you understand?
Yes, ma'am.
Okay.
Thank you.
But we will not have any interrupting of anybody. I'm not going to let him interrupt you, and I'm not going to let you interrupt him. Okay? Does that sound fair?
Yes, great. Thank you.
Okay. Please, counsel, please finish.
Oh, yes, thank you, Judge. So yes, as I was saying before, during docket call this morning, I had explained these things to Judge Vara, but she told me to not address that with her, to address it with you, which is what I'm wanting to do now, which is just have a hearing on whether we can reset this trial date. And if I may, I can explain the reasons why, if I can. The main reasons are in advance of a trial, which may have been held today, my office did not receive certain trial exhibits that Ms. Walker apparently shared with the court, which is, I believe it's required by local rule that, exhibits to be introduced at trial need to be shared with the opposing party. This morning, I went on the docket online and saw that there was some evidence shared with the court last week from Ms. Walker, and I didn't get to review that evidence. So that's one of the primary reasons why I think it's in the interest of the parties and also the court to consolidate all these claims into one cause, to just reset it at a future time so we can just serve the interest of justice and efficiency, Your Honor.
Okay. And this is this an eviction appeal?
No, ma'am, it is not. It's not an eviction appeal.
Okay, what is it? What's the main cause of action?
Well, Your Honor, I think it's helpful to give some context then, because I don't want to be inaccurate, because the new claims, admittedly, I can assume what I think they're about, but I don't know for sure, because there were two phases of cases that occurred in the JP court, Your Honor. The first phase were claims that Ms. Walker filed in November of last year. And those claims, I believe, were for breach of contract and some other claims but they were mostly revolved around just a payment to the apartment complex that I represent. And whether a credit was properly applied or not, because Ms. Walker received some government assistance. I don't want to get into the facts too much on that, because that's going to be an argument that we can save for a later time. But those claims in phase one were dismissed by the JP court for failure to state a claim in March. And then after those claims were dismissed, Ms. Walker filed new claims in the JP court, again, without having served my client with those new claims. And those claims were dismissed for jurisdictional reasons, and they were appealed. And in looking at the appellate record for all three causes, Your Honor, it's difficult to figure out what the basis is for a lot of these claims. And again, a lot of these new claims that are referenced on the notice of appeal are actually not claims that were brought in the JP court during that phase two claims that I was describing.
Okay.
So this is what we learn.
I apologize. I asked the wrong question. I wanted to ascertain, what are we here for today? Is it for, you mentioned trial a couple of times.
Yes, ma'am. Yes. So we are here today because there were 3 notices of hearings that were filed in June. And my understanding was the hearing would be to set a trial date, but that was my mistake. It sounds like the court procedures are, a trial may go forward on the date on these notices, which is August 5th, today's date, Your Honor. And I'm just requesting that we just reset the trial date for a later time, because my office has not received the trial exhibits that were shared with the court. And again, we have 3 separate causes with 15 total causes of action. I think it would be beneficial to the court if we just reset this hearing to give my office a chance to, again, review the exhibits and also maybe submit some papers to the court to try to get some of these claims dismissed, Your Honor.
Ms. Walker.
Yes, ma'am.
Are you an attorney?
No, ma'am.
Okay, but you're the plaintiff in this case.
Yes, ma'am.
Okay, you're the one who's bringing the lawsuit suing Regency Property Management, correct?
Yes, ma'am.
Okay, so the thing here is, are we here for a trial, or what are we here for? What reason is this matter set for today? For what purpose?
It was my understanding it was for a trial.
Okay, your understanding it is for trial, and you are ready to go to trial?
Yes, ma'am.
Okay, ma'am, you're ready to go to, and please, I want to go ahead and just, are we going to do a bench trial, or Is it a jury trial?
When I first, I need to make a statement to you first, Your Honor. I apologize. I do have hypoglycemia, and so my sugar often drops. So if I repeat myself, I apologize. If you could give me a second to collect myself, I can come back quickly, or if I need to eat something, I have candy right here. But when I did the appeal paperwork and I had to go downtown to get this paperwork to present it to the defense, it was my understanding that if I wanted a jury trial, that would be separate paperwork. So I believe this was for a bench trial.
Okay. So how long do you think that trial is going to take?
I had put an hour and a half.
Okay.
But it probably will be less, but just in case I'm not doing well.
All right. Now, there are 3 very thick files. I mean, 3 of them are about the same thickness.
Yes, ma'am.
Okay. The defense has right now basically kind of told me that they don't have some documents as far as some evidence, or no, not evidence, but some claims and all of this. So they're not really too sure what all the issues or claims are. So would it be okay for you guys, for me to put you guys in a breakout room so you can sort out some of the issues and all of that? We won't be able to have a trial today. I think you can appreciate that. So I'll have to set you for a trial date, okay? So
May I
that
make a
we
statement?
can, ma'am?
May I make a statement to that?
Sure, as soon as I'm done. Would
Yes,
that be
ma'am.
okay?
Yes,
Okay.
ma'am.
So I won't be able to go ahead and hear a trial case today, period. Just to let you know that there's just too much time. And so what I would like to do is put you guys in a breakout room, and this is what we do, is just to be able to go ahead. First of all, have you guys tried to mediate?
Yes, ma'am.
You have
Yes, ma'am.
gone to mediation?
Informally.
Yeah, Your Honor, my understanding is that before any claims were filed in the JP court, there was a mediation. I was not involved in the mediation, but I believe that happened last summer, if I'm not mistaken. And ever since, we have diligently tried to resolve this out of court, but to no avail, unfortunately.
I've had 3 mediations with the defense through Bexar County Resolution Center to try to resolve this.
Sir, when did Mr. Stricker, when did you get on the case?
Yes, my firm was retained on the case, I believe in December or January. It's about 8 months ago.
December 2021?
Yes, ma'am.
And you have been the lead attorney on this?
It's been, well, that's a great question. I'm supervised by my partner at my law firm, but I've been involved in the hearings at the JP court, and yes, that's a long way of answering your question. Yes, I'm the lead attorney.
Okay. And are you going to, basically, is this matter for you to handle from your law firm?
Yes, ma'am. Yes,
okay, you're assigned. Okay. All righty. So Ms. Walker, have you had opportunity to try to mediate with this particular attorney?
Yes, ma'am, on several occasions.
Okay. Of the 3 mediations you said that you had at Bexar County, was Mr. Stryker involved?
No, ma'am.
So, because mediation is a thing, okay? It is a structured event. So even though you've talked with others, the defense has retained a law firm about 6 months ago or 8 months ago, December, and this is the lead attorney in that case. Do you think that another round of mediation may be beneficial?
It wouldn't hurt, Your Honor. I'm not opposed to it.
All right.
But I do want
Alrighty.
to.
No, I'm
can I-
going to let you go ahead and make your statement. So proceed then.
Yes, ma'am. Mr. Stricker has been with them since October. I've had communication with them starting the beginning of November.
Oh, you've been talking to Mr.
Yes, ma'am.
Stricker since November?
Yes, ma'am. Give me 1 second. I can give you that date. Since November 9th of 2021.
Okay.
And I believe there was a mediation in December.
At Bear County Dispute Resolution Center?
Yes, ma'am.
With Mr. Stricker involved?
I believe they had declined to mediate at that time.
Okay, if they declined to mediate and so therefore did not show up, you may have had one scheduled, but did you actually have mediation?
I did. They did decline to mediate. I believe I have that paperwork with the Resolution Center.
Okay, so there was no mediation in December. One was scheduled in December, but
Yes,
nothing happened.
Yes, ma'am.
Okay, all right. Give me 2 seconds. Please, Blanco. Okay. All right. Okay, so all right, so what statement did you want to make at this time? Because right now even though it's being electronically recorded, we're just kind of off the records. And I just want to get you guys straightened up so that we can know what we're going to do with these cases.
That was it, Your Honor, about my sugar and then those, correcting on those few things. That was it.
Correcting what few things?
Oh, on the dates that he was saying. That was it.
Oh, okay. All righty. So we're looking at mediation. Is there a reason, Attorney Stricker, that you guys declined mediation?
Well, yeah, Your Honor, it's my understanding, I've been on the case, it may be since November, I thought it was December, but I have no recollection of a mediation ever being requested and being declined, anything like that. I mean, I don't recall anything involving mediation having come up since I've been on the case. So it may be that this happened before I was retained, but I do not recall mediation ever being attempted or definitely not occurring.
Okay, that's no problem. I'm going to order that, and the dispute resolution center will go ahead and send me something back. All right, so that's 1. 2, I'm going to put you guys in a breakout room for you guys to discuss. These are the 2 things that I do wish for you to go ahead and come back with. 1, a possible consolidation of all of these 3 cases. Ms. Walker, do you think that's possible to put all of these 3 cases together in one case, under one cause number?
Yes, Your Honor.
It's called
And
consolidation.
That's what, that was the other thing. And I apologize for my disability on that. At the time that I put these three in, the instructions that were given to me is based off of the dates. So each case happened during certain time period. I don't mind consolidating them.
Hang on 2 seconds, please. I'm sorry, I have to take this. Okay, so we're looking at consolidation. And then also, Ms. Walker, do you think that we could possibly, when you're gonna consolidate, you're gonna list down all of the claims and everything that you want to see happen, right?
Yes, ma'am.
Okay. All right. And then, and then perhaps through either the mediation or you guys talking now, you can look at all the issues, claims, and be able to narrow down what we call, kind of narrow down the issues, what I really, really have to discuss or figure out for you guys, okay?
Yes, ma'am.
All right. Then the fourth thing that I kind of want to happen is for you guys to figure out a date that we can be able to, you guys look at everything, get everything done, get your mediation done, and a date for you guys to come back and do a bench trial. Okay, so trial date. So we'll need mediation done, and you guys get a date for that you can mediate, and then we need a trial date, okay? You're going to talk about consolidating all three cause numbers, and then you're going to see if you can narrow down. Maybe there's some things that you guys can agree on, and then narrow down the issues, okay?
Yes, ma'am.
Yes, Judge.
Alrighty. So I'm gonna let you guys do that. If you can come back. Let me give you till about 4 o'clock. If you guys can come back at 4 o'clock and give me the dates for the mediation and the trial date, that would be great. Okay?
Yes, Judge.
All righty. And does that sound okay, Ms. Walker?
Yes, ma'am. Do we just want to get clarification? Is it through a Zoom break room or is this off separate?
It's a Zoom break room.
Okay. Okay.
Yeah, and Judge, I just want to clarify. So the only two things you want from us, we'll discuss those other issues, but you just want us to have dates for mediation and for a trial date. That's what we have to provide to you, correct?
Right.
All right, understood.
Because, and you guys have already agreed here. My understanding is that you want to consolidate all these three cases. That's what you said, Attorney Stricker, and that's what you said, Ms. Walker, correct?
Yes, Judge.
Yes, Your Honor. I don't mind
Okay.
consolidating them.
So we have an agreement on that. And so
Yes.
you guys are gonna have to Attorney Stricker, you're gonna have to kind of work that out, how you guys are gonna do that, okay?
Yes, understood.
cooperate
Your
and
Honor,
help each other out and consolidating it. So then the
You-
only other thing, go ahead.
you want a separate mediation date and not for today. Am I understanding that?
Well, yeah, I don't set those mediation dates. You guys, I'm giving you till 4 o'clock today to come back to me because you have to call the Dispute Resolution Center and see what dates are available.
I understand now. Got it. Do another.
And then once you get that date, what dates are available from the Dispute Resolution Center, then you can figure out a date for trial. But in doing that, you guys are going to have to kind of work through all the claims and issues in this case, in these 3 CAS numbers. After, because you guys have agreed to consolidate it. Now you're gonna have to work out through all the issues and claims and see if you can narrow them down to just a few things maybe that I have to decide on, okay?
Yes, Your Honor. I understand.
I have a question, Your Honor. Is there a date by which you would like us to have all those claims consolidated?
Well,
I was gonna do it today.
Sure. It's just gonna move as fast as you guys want to go ahead and resolve this matter. See what the Dispute Resolution Center has to offer you. And then as far as the trial, Wednesday will be the best, a Wednesday, okay? Would be pretty good.
This
okay?
Wednesday, is that what you said, Your Honor?
No, a Wednesday.
Oh, a Wednesday like that. Okay.
Right. So first, we gotta go to and talk to Dispute Resolution Center, see when they can get you in for mediation, right?
Yes, ma'am.
Then this is the thick of the file. Do you see this? This is how thick one file I have is.
Yes, ma'am.
All
It's a
3
lot.
of them are the same.
Right. Yes, ma'am.
So you're gonna try to get these. This is all 3 of them.
Yes,
You're
ma'am.
going to try to get these down to the issues and the claims and everything like that. So you guys understand coming forward what you're fighting about. I'm thinking that once you go through and start looking at all these things, that you're going to say, oh, okay, maybe that's not a fight. Maybe we can agree on that. Maybe we can, and toss out issues and claims and things of that nature. So you bring it down to maybe 1 to 4 things that I may need to actually make a decision on after I hear all of your evidence.
Yes, Judge. Understood.
Yes, ma'am.
Are you with me, Ms. Walker?
Yes, ma'am. I don't know about the thickness of one case, but putting them all together, I see what I did, but I don't think that's going to change the documentation, though. It's
Well,
just
I'm not saying to change the documentation. It can still be here, but maybe there's a duplication of claims. I don't know.
there is. I see what I did. There is, Your Honor.
So I see. I got this just
Yeah.
a couple hours ago. So what I want you to do is kind of narrow it down. Have a chance to talk to Mr. Stricker. Narrow it down about issues and claims, and he's going to kind of help you flush out and make sure that you understand what that means. Okay.
Yes,
You're
ma'am.
going to work with her on that, right, Mr. Stricker? I mean,
Yes,
to a
Judge.
certain level.
Yes.
Okay. All righty. And then once you guys have done that, then you discuss and say, okay, this is a date that we will need to, because we still do not agree on these things. Okay.
Yes, ma'am.
Yes, Your Honor.
All right.
Thank you.
Okay. And I'm just saying to you, just for planning purposes, for trial in this court with me, you're looking at a Wednesday would be best, Wednesday morning, okay?
Yes, ma'am.
Thanks, Judge.
All right.
Wednesday morning.
Are we good?
Wednesday morning.
Okay, so
Wednesday
4
morning.
o'clock, you come back and you give me 2 dates. And you give me maybe a third date if you want to go ahead and have me kind of monitor for compliance and cooperation and all that. And say, hey, by this time that we're going to have all the issues narrowed, discussed, and narrowed down, okay? The consolidation is going to, you can give me that date too. And we can make sure of that and then look at maybe there's some other thing that we need to discuss. Why don't we do that?
Your Honor, I apologize.
Okay, you didn't understand what I just said?
You said Wednesday mornings.
It's okay.
And you then said
Okay.
that something
Ms.
else would be best.
Walker, I'm going to go ahead and repeat my instructions here so we're clear.
Yes, Wednesday mornings.
Mediation date. I need 3 dates from you.
3 dates.
Mediation date. A date when you have all the issues and claims and consolidation and all the issues and claims narrowed down, okay? And we're gonna come together and we're going to make sure that those are, that is done.
Yes,
And
ma'am.
then
Okay.
And then a trial date.
Okay, that's yes. Okay, I think coming back around now, sorry. Consolidation date, mediation date, trial date. Got it.
Gotcha. First one, I have no control over.
Right.
That's on Dispute Resolution Center.
Yes, ma'am.
Number 2 and 3, try to pick on Wednesday, okay? And
Yes,
I
ma'am.
can go ahead and when you guys come back, I'll put you with my court coordinator. She'll be here and we'll be able to go ahead and figure it out, okay?
Yes, ma'am.
All righty, sounds good. See you guys at 4.
Thanks, Judge.
Thanks.
And it's the same back channel, the same Zoom number, okay? See you at 4
Okay,
p.m.
do we go? Okay. All right,
Thank you.
thanks.
Thanks, Judge.
Ms. Klonek,
Yes, ma'am. Yes, ma'am.
have you contacted Julia Crone?
Yes, ma'am. I did contact her and I did speak to her and she said that she didn't have a way to get on Zoom and that she is vacating the house as we're speaking right now. And I said, well, maybe the judge would like to call you and speak to you directly if you can get Zoom. So I'm not sure how you would like to handle that. She can answer her phone, but she cannot do Zoom.
But she's vacating.
She's vacating. She said she's vacating the house.
Well, why don't you guys talk, see if you can come up with an agreement, and then you can come and tell me what the agreement is.
Your Honor, how about if we get the judgment and if she doesn't vacate, then we can come back and do the writ. She owes $20,000. She's been there 3 years without paying any utilities, rent.
Ma'am,
and
you're
Mr. Saldana-
trying to put, ma'am,
Yes, ma'am.
so why don't you two talk since you're communicating, and then you come back, if she can come back, okay, if not, you come back with an agreement. See that? The agreement can be, hey, we're gonna file a judgment and such, okay? So she's vacating now. That's what you really want her to do.
Correct.
1. 2, you might wanna talk about some money or something like that. You know, what I can do for you is get her out of there, money and all this kind of good stuff. So why don't you talk, see if you can come to an agreement, what you want to have happen, and you guys come back at 4 o'clock and tell me about it, okay?
Okay, Judge, will do. Thank you.
Great, thank you.
Goodbye. Oh my God.
Attorney Damaris, you're here.
Yes, ma'am. My client is here as well, John Goodwin.
Good one. Okay, thank you. Let me go ahead and pull that file.
Thank you, Judge.
What is that cross number again?
Cause number, Your Honor, is 685052.
Attorney Damari, what are we going to do with your case?
So, Your Honor, my client was just indicted last month on a felony case out of the 379th, I believe.
Yes, sir.
I am not the attorney on that case. I don't know if they will appoint me to it. I can ask them. But in lieu, because of that new setting, and this is our second year, I would ask for what the court's, deference is to it as far as a reset or as far as a trial setting, whatever the court deems would be most appropriate for me to get time to see what's going to happen with the felony.
Okay. Counsel, 2 seconds.
I guess if you're asking me, Judge, I'd ask for 60 days to get on the felony, see if I can work it out, take this case into consideration.
So he doesn't, you say he doesn't have an attorney on that felony case?
No, ma'am.
Okay, great. Let's go ahead and do that. We'll go ahead and do a felony pending reset. Alrighty, sir. Let me go ahead and put you in with the court coordinator, Mr. Goodwin.
Yes, ma'am.
Alrighty, so I'm going to go ahead and put you in a breakout room with your attorney so that we can make sure that we have all that information. Your Attorney Damari, just a good email address on your client for the case setting form. And you take a look at your, consult your calendar now, okay, sir?
Yes, ma'am. And then talk to the court coordinator?
Yes, sir. And you and your clients are excused from there, okay, sir?
Thank you, Judge. And John, if you see a blue button, join that breakout room. Click on your phone. Thank you.
Deputy, I'm sending you a couple of people, okay? They need to go ahead and you need to talk to. Ms. Morgan, if you will go ahead and join the deputy, accept that invitation, please. And the person at Galaxy A12, if you will go ahead and accept that invitation. Attorney Cuellar. Are you?
Yes, Your Honor. Yes, Your Honor.
I've looked at the paperwork. Would you have issues concerning the personal data sheet? Would you like to get in there and talk with your client about that? And or let me have you talk with my court coordinator. Maybe she can be able to assist you with that. Let me go ahead and put you in that room. Say again. Oh, sorry about that. There you go. Does anyone need to go ahead and talk with the ADA? Again, I still think I only have one ADA. Attorney ADA Ling, Han Martinez is still, or is ADA
Judge.
Sanchez helping you out this afternoon?
Judge, I'm present as well.
Great. Who's going to be conferring?
Judge Julie Pollock, I need to confer. I've got.
Okay.
Judge, I'm happy to confer.
I'll go ahead and, please go ahead and put Ms. Pollock in with the ADA Han Martinez. Yes.
Judge, I just need to approach when the court has a second.
Okay, sir. All right. Attorney Rutledge, if you will go ahead and join me in the, I sent you an invitation. Please go ahead and accept that invitation, sir.
What's that for, Judge? The breakout room?
Yes. And Attorney Thorne? Attorney
Sorry,
Thorne?
yes, Your Honor, I'm here for a plea. Can you hear me?
Okay. Yes.
And my client is on. I see him, Mr. Lejeune.
We completed the paperwork
Thank you.
today, so hopefully you have it.
Okay. Attorney Hicks, do you need to speak with the ADA?
Your Honor.
You need to speak with
Notices.
confer with an ADA, sir?
I'm trying to answer your question.
Okay.
I received notice of this hearing and of this defendant when I got it about 7 o'clock last night, when I checked my email at home. And when I got to the office this morning, I downloaded the e-discovery, but it will not be ready for at least 24 hours. So I'm going to have to request that the case be recalled to a later date.
Yes, sir. Let me go ahead and take a look at that file. Thank you. State, if you will go ahead and pull up these cases in order, 681, 682. 684-096. 682-157. 670-803.
'Cause
That last one was 670-803.
And that's the last one, Your Honor?
Yes, so far.
Okay.
Mr. Hicks, what was your cause number, please?
It is 685142, Your Honor.
Attorney Hicks, I don't have your file up here. I've requested for it to be sent to me, so you can follow up on that. You can call the court and have the file brought to me, okay? So let me take a look at it. Attorney Martinez?
Yes, Your Honor.
Alrighty. On cause number 681-682, you've discussed with the state?
Yes, Judge, they've indicated that they're going to be withdrawing that motion, Judge.
Okay.
Ms. Cruz was in this morning, but she had to go to a doctor's appointment.
ADA Sanchez, are you ready on that particular case, or do you need to confer with ADA Harness, a motion to revoke?
Judge, if I can just hop into that breakout room really quick, just to see what they wanted to do with it. I'm not really privy to that solution.
Just so you know, Karina, she had indicated this morning to Victoria that she was going to withdraw the motion.
Okay, let me just go talk to her briefly. I'll be right back.
Okay.
Thank you. Okay, Judge, I'm back. Thank you so much.
And not a problem. Give me 2 seconds. Okay, just waiting on this matter, on the Blanco case, we're just waiting for the court liaison officer to join us. She hasn't joined us yet. I've sent her a message to do that. Miss Luna, would you be able to go ahead and give her a call for me as well? If she is in. Counsel, did your client show up, Mr. George Luna? George and Hal Luna? Counsel, how much time do you need in order to be able to go ahead and try to get a hold of your client? He did not answer the docket this morning. He's here for an arraignment. Can I give you to the 15th of August, or do you need just a little bit more time?
Just a second, let me look at my calendar. I should be able to try to get in touch with him by the 15th, yes. I'll also have time to download the discovery and find out something about the case, which does not look too terribly complicated.
So I'll give you to the 15th of August to get a hold of your client. When you do, and if and when you do, please let him know that he needs to come to the courthouse, sign in, check in with the court, so that we can get up-to-date information on him. Also, hopefully be beneficial to you. And I will issue a judge's warrant on or before the 5th, on the 15th of August, if he has not shown in and checked in with the court.
Absolutely.
Once he does that, sir, then we'll be able to go ahead and proceed with other matters.
All right. Thank you, Your Honor.
Thank
I believe
you,
this
Counselor.
concludes my business with the court. May I be excused?
Yes, sir, absolutely. Thank you. Appreciate you taking on that case. Okay. State, are you ready on cause number 684096?
Yes, Your Honor.
And defense, you ready to proceed on that case?
I am, Your Honor. My client, Dick Dow, should be in the courtroom.
All right. Deputy, could we have Mr. Dowell placed in the prosecutor table so that he'll be able to participate?
Yes, sir. Yes, sir.
Let us get on record on cause number 684096, State of Texas versus Dick Basilio Dowell. Parties, please approach and identify who's before the court, starting with the state.
Rena Sanchez for the state.
Did we lose the attorney Rutledge? Attorney Rutledge? Okay, thanks. It's not my microphone. Attorney Rutledge? Attorney Rutledge?
Yes, Judge. I'm Mark Rutledge. I'm here for the defendant, Mr. Dick Dow.
Are you Mr. Jake Basilio Dowell?
Yes, ma'am, I am.
Are you the same person who has been accused of driving while intoxicated, alleged to have occurred on the first day of May 2022 and classified as a Class B misdemeanor? Are you the same so accused?
Yes, Your Honor.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing else but the truth, under pains and penalties of perjury, so help you God?
I do.
Thank you. You may go ahead and lower your hand. Court is going to start sharing the court's screen. Mr. Dowell, can you see the court screen?
Yes, ma'am.
And counsel, can you see the court screen?
Yes, Your Honor.
And state?
Yes, Your Honor, I can see the screen.
And we are operating hybrid as the defendant is physically in the courtroom and both the state and the defense attorney is on Zoom, just for the record. State, do you undisplays a document that's entitled State's Consent to Video Conferencing? Did you sign this document that's consenting to these proceedings by video conferencing?
Your Honor, ADA Boses did sign this document and I adopted as my own. The state has signed the video conference consent.
State's video conferencing consent is made part of the record. Defense undisplays a document entitled Defendant's Consent to Video Conferencing. Mr. Dowell, is this your signature where I am circling the cursor?
Yes, Your Honor.
Did you sign this document that's consenting to plea by video conferencing?
Yes, Your Honor.
Counsel, with your signature on the same document, do you join your client in consenting to these proceedings by video conferencing?
I do, Your Honor.
Defendant's video conferencing consent is made part of the record. Counsel, how long have you been representing Mr. Dowell?
Over a year.
And are we applying for probation? And if so, what type?
It's deferred adjudication, Judge.
And Mr. Dowell, I draw your attention to the document on display. It's entitled Application for Deferred Adjudication Community Supervision. This is a 2-page document, this being the first page. This is the second page. I draw your attention specifically to the area where I am circling the cursor now, where about the middle of the page of the second page. It says that you personally appeared before me, you are here in the courtroom, that you are the defendant in this case, and that you have been sworn in under oath. You are going to tell me that your application for deferred adjudication community supervision and a document entitled your personal data sheet, which is going to be attached as an exhibit to your application, is true and correct. I'm going to share with you your personal data sheet. Keep in mind that if it's not completely filled in, sir, it cannot be true and correct. And all I need for you to identify for me is if there's any corrections that need to be made or things that need to be added in, okay? All right, sir, any corrections that need to be made?
Yes, Your Honor. On the mailing address, it should read 510 West Byron.
Okay, sir, you'll be able to make those corrections once printed, right?
Yes, ma'am.
Okay, and your wages and position and supervisor, you'll be able to provide that information. And whether you're employed or full-time, part-time, you'll be able to correct all that, right, sir?
Yes, ma'am.
All righty, okay. Mr. Dowell, do you need to speak with your attorney before, to understand the consequences of this statement before you answer it. Defendant understands and acknowledges that any untrue statement in your application or in the exhibit, your personal data sheet, may be grounds for denial or revocation of any community supervision in this case. Do you need to speak to your attorney?
No, ma'am.
And so what is your response, sir? Do you understand and so acknowledge?
Yes, ma'am.
I will sign the document and make it part of the record. State, have you fulfilled your discovery and Brady requirement in this case?
Yes, Your Honor.
Counsel, are you satisfied that the state has fulfilled its obligation to provide you discovery under Article 39.14 of the Texas Code of Criminal Procedure, as well as giving you full access to the state's file?
Yes, I am.
And state, is this matter subject to law enforcement disclosure requirement? And if it is, has that been complied with?
Yes, Your Honor, it is. The offense date is 5/1 of 2022. So that is a requirement and the state has complied.
Thank you, state. I will sign the discovery acknowledgement, making it part of the record. State, do you have any motions for the court's consideration at this time?
No, Your Honor.
Defense?
No, Your Honor.
Mr. Dowell, I draw your attention to the document on display. It's entitled Defendant's Waiver of Constitutional Rights and Court's Admonitions. This is a two-page document. This is the first page, and then this is the second page. Mr. Dowell, is this your signature where I'm circling the cursor?
Yes, Your Honor.
Did you review this document with your attorney?
Yes, Your Honor.
After you reviewed it with your attorney, sir, did you freely and voluntarily sign this two-page document?
Yes, Your Honor.
And so with your signature and testimony now, you're telling me that you understand everything in this two-page document as it was reviewed and explained to you by your attorney?
Yes, Your Honor.
And you satisfied with the representation of your attorney?
Yes, Your Honor.
He has worked very well for you to be able to go ahead and bring this to a resolution for you today. Sir, do you understand the range of punishment in this case?
Yes, Your Honor.
Do you understand your constitutional rights?
Yes, Your Honor.
With your understanding, do you then voluntarily and freely give up your constitutional rights?
Yes, Your Honor.
Are you a U.S. citizen, sir?
Yes, Your Honor.
I will approve of your jury waiver. I am going to sign it, make it part of the record, sir. You will no longer be able to have a trial in this case. Counsel, do you believe that your client is competent to enter into a plea today?
I believe he is, Your Honor.
With the information, were you able to apprise this defendant of the nature of the offense and the charges against him?
Yes, I was, Your Honor.
Do you and this defendant then waive the formal reading of this information?
Yes, Your Honor.
State, what is your punishment recommendation?
Your Honor, the recommendation is a $500 fine with court costs, 18 months deferred adjudication, DWI education course, uimpact.com, a TAP evaluation, 48 hours of community service, and ignition interlock for half the term.
Counsel, is that your understanding of the state's punishment recommendation to the court?
Yes, Your Honor.
Mr. Dowell, is that your understanding of what your attorney has worked out with the state on your behalf in order to dispose of this matter today?
Yes, Your Honor.
With that understanding, sir, how do you wish to plead? Guilty, not guilty, or no contest?
No contest.
Now, do you understand that even though you're pleading no contest, sir, I can still find you guilty?
Yes, Your Honor.
And you still wish to proceed?
Yes, Your Honor.
Now, you've discussed this entire matter with your attorney, haven't you?
Yes, Your Honor.
And so with your plea of no contest, you're telling this court that you do not wish to fight any of the charges in this case?
That's correct, Your Honor.
And then with your plea of no contest, after discussing with your attorney, you feel that that plea of no contest is in your best interest?
Yes, Your Honor.
I will accept your plea of no contest, finding that it's intelligently and freely made and that you're competent to do so. Counsel, what, if anything, on behalf of your client, and why should I consider this plea?
Your Honor, my client regrets what happened wholeheartedly. He actually wrecked his car during the accident. But I've worked out with the state that the offer is good. It's a good offer for my client, and he's willing to do whatever the court is asking him to do, and he'll complete it successfully.
Thank you, counsel. Very helpful. Mr. Dowell, whom do you live with?
I live by myself.
Do you have the ignition interlock on your vehicle at this time, sir?
No, ma'am, I don't. My car is still in the shop and won't be available until maybe October, November, from what they're telling me right now.
So how many vehicles you have in the household?
Zero.
Right. What do you mean? You do have a vehicle that you own, right? It's
Oh,
just
yes, sir.
in the
Yes.
shop.
Just one vehicle. Yeah.
State, what was the BAC in this case?
A 0.14, Your Honor.
There are no prior cases, are there?
No, Your Honor.
So what are your wages?
Right now, before or take home? Like before?
Whichever one you wish to provide me, sir.
I must say around averaging about $700 a week.
With the employer have his formal automotive, sir, what do you do for them?
I am a material handler. I receive and all material stock and also send out parts.
Okay, you don't drive?
No, ma'am.
Okay. State, was there an accident involved with this case?
Yes, Judge, it was a single vehicle accident. There were no other people involved, no victims.
So who was the accident with, or what was the accident with?
Your Honor, it was just the defendant that he crashed into a barricade on 281, single vehicle accident, Your Honor.
Nothing is owed to the city?
Not to my knowledge, Judge.
Okay. State, do you have any objections regarding this defendant being referred to Bear County Gives Back program to satisfy up to 40 hours, only 40 hours of the community, 40 hours of the 48 hours of community service?
No objections, Your Honor.
Counsel, are you familiar with the program?
Yes, Your Honor. And I have no objection, Your Honor.
Counsel, is there any legal reason why this matter cannot be disposed of today?
Not that I know of, Your Honor.
Mr. Dow, although there's sufficient evidence to find you guilty in this case, I am going to withhold my finding of guilt. I am going to place you on 18 months of deferred adjudication probation, deferred adjudication community supervision, probation for DWI first. You will be supervised and monitored by the Bear County Community Supervision and Corrections Department, otherwise known as probation, with these following conditions: $500 fine plus court costs. DWI education, duimpact.com, TAP evaluation, 48 hours of community service restitution. I'm going to refer you to Bear County Gives Back program for 40 hours of the 48 hours. Ignition interlock for half the term to be installed within 30 days. I'm going to, and in the meantime, I usually require that in 10 days. In the meantime, you'll be providing UAs. You'll be monitored with UAs, random UAs on a weekly basis. I will need two affidavits from you. One, that you will not drive any vehicle that's not equipped with an ignition interlock. And two, the status of the vehicle that was involved in this incident with third-party verification. I'm going to set your supervision fee at $45. With the ignition interlock and the status of the vehicle, the third-party verification, you have indicated to me that it's in the shop. So I need that shop to go ahead and provide something that you'll provide to your community supervision officer.
Okay.
And then we'll continue to go ahead and monitor that. You'll be monitored by UAs until we can go ahead and get an ignition interlock on there. Or I can order for you to be on a portable alcohol monitoring device now, and then when you get your vehicle back, we can switch it out to an ignition interlock.
And it would be 6 months total combined, or?
Yes, sir.
Okay.
No, it's half the term, sir.
Oh, okay.
So about 9 months.
9 months? Yes, ma'am.
So which one do you want? The UAs or the portable alcohol monitoring device?
Do the portable.
Okay. So you'll get that portable alcohol monitoring device in 10 days. You'll have that installed in 10 days. And once your vehicle becomes available, sir, then we'll switch it over to ignition interlock, okay?
Yes, ma'am.
All righty. State, did I cover everything for you?
Yes, Your Honor, thank you.
Counsel, is there anything further on this matter?
No, Your Honor. Thank you.
Yes, sir. Mr. Dowell, with regards to the trial court certification of defendant's right to appeal, this has been a plea bargain case. I am going to certify that you have no right to appeal. You'll be able to go ahead and pick up this document when you come down to give us your fingerprints. When will you be able to do that, sir? Monday?
Oh, yes,
Tuesday
ma'am.
or Wednesday?
Monday would be fine.
Monday?
Yes, ma'am.
Sir, you'll be coming back down here to County Court at Law Number 2. You know where it's located, 300 De La Rosa, San Antonio, Texas, 78205. We are on the first floor of the Cadena Reef Center. You're here, you found it. Now, sir, you'll be coming back on Monday between the hours of 2 p.m. and before 4:30 p.m. Understand, if you don't show up on Monday, a warrant will be issued for your arrest. Do you understand, sir?
Yes, Your Honor.
Okay. Sir, further, the Bexar County Gives Back program is an alternative. It's one of the ways that I offer you to be able to complete the community service restitution. If you wish to participate in it, that's fine. If not, you get to satisfy 40 hours. Okay, my CLO will explain that to you. If not, sir, you're still responsible for the entire 48 hours of community service restitution, okay?
Yes, ma'am.
All righty, sir. Your attorney and everything is indicated that this was just a bump in the road for you.
Yes, ma'am.
You lived a little bit here in life.
Yes, sir.
And so, sir, I expect you to continue being the contributing citizen that you are to the Bexar County community. And thank you very much for coming down here and taking care of it. If anything occurs in the 18 months that you need adjustments or anything of that nature, please speak to your community supervision officer to be able to see if they can make adjustments. And you have a very fine attorney who's a little bit under the weather, but he still said, hey, he's gonna trudge on and get you taken care of today, okay?
Yes, I agree with you.
All
Yes,
right,
ma'am.
so he'll be able to straighten things out for you. So thank you for coming down. I'm going to go put you in the back room there so you can talk with the CLO and she can see if you're eligible for a Bexar County Gives Back program.
Okay, thank you, Your Honor.
Thank you
Thank
very
you.
much. Appreciate your time.
Thank you, Judge. Let me be excused.
Attorney Rutledge,
Yes, Your Honor.
I hope you get to feeling better, swift recovery on that cold. Sir, did you need to go in the breakout room with the CLO as well?
No, I'm fine, Your Honor. Okay.
Okay, you and your client will be excused, you're excused, and as soon as the CLO gets done with him, she'll excuse him from there as well, okay, sir?
Thank you, Your Honor. Have a good weekend.
Okay, have a good weekend. Thanks, feel better. You wanna let him know? Attorney Ornelas, if you go ahead and check your chat. Alrighty, Attorney Cuellar? Attorney David Cuellar? Attorney Pollack?
Yes, ma'am. Do you want announcements on my cases?
What are we doing here?
On Kiana Morgan and Ray Dominguez, I believe these are arraignment settings. We don't have all of our discovery in those cases because they're so new. So we would ask for.
Not a problem. Could you go ahead and give me the case number on Kiana Morgan, please?
That is case number 686-221.
Okay, let's discuss that one first. That's an arraignment.
I believe that's the setting today.
Alrighty, so you want to go ahead and set that for a pretrial conference hearing?
Correct.
Okay, not a problem. We'll go ahead and get you in the breakout room with the court coordinator to get those dates. Please consult your calendar. Who else do you have?
Ray Dominguez.
Yes, I believe Roy Dominguez did answer the docket as well as, and that's also an arraignment. We want to go ahead and reset that one for a pretrial conference hearing as well.
Yes, Judge.
Alrighty, and then you have Mr. Daniel Gonzalez,
Correct.
and he also answered the docket for you. And are we going to set that one for pretrial conference hearing as well?
Yes, Judge.
Okay. Ma'am, I'm going to put you in a breakout room with the court coordinator. From there, you and your clients are excused. I'll put you, 4 of you in with the court coordinator, okay? So make sure we have good contact information by email. You've got it?
Thank you.
Okay, state you have cause number 670-803.
Yes, Judge.
Counsel, are you ready to proceed on that case? You may be muted, counsel. Attorney Thorne?
I'm sorry, Your Honor, I didn't hear the case. Yes, I'm
Oh,
ready.
670-803?
Yes, that's my client, Mr. Lejean. I apologize. Sorry.
Not a problem. The personnel data sheet is completely blank. Can I put you in with the court
I filled
coordinator
it out
to?
this morning.
It's blank
It's blank?
from what I'm seeing. Pimentel, right? No, I'm sorry. I pulled up the wrong case. Sorry. They're working on that. Sorry.
Lejean, Jules Lejean.
Thank you. I pulled up the wrong case.
I know I filled it out
Right?
on my phone with my chubby little fingers. It was very hard.
Uh-oh.
When I
I
was.
have to get you one of these. All right. Okay, counsel, you ready to go ahead and proceed?
I have, Your
And
Honor.
state you have it. Okay. Let us get on record on cause number 670-803, State of Texas versus Jewel Tour Lejean. The middle name is spelled Toure and Lejean Lijon. Parties, please approach and identify who's before the court, starting with the state.
Karina Sanchez for the state.
Sharon Thorne is the defendant.
Are you Jewel Tour Lejean?
Yes, ma'am.
Okay. Can you tell me how to pronounce your middle name correctly?
Teray?
Touré. Okay, thank you, Touré. And it's Lejean?
Yes, ma'am.
Okay. Are you the same that has been accused of driving while intoxicated with a BAC of 0.15 or higher, alleged to have occurred on the 2nd of October, 2021, classified as a Class A misdemeanor? Are you the same so accused?
Yes, ma'am.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing else but the truth, under pains and penalties of perjury, so help you God?
Yes, ma'am.
Thank you. You may go ahead and lower your right hand. I am going to start sharing the court screen at this time. Mr. Lejean, can you see the court screen?
Yes, ma'am.
Counsel?
Yes, Your Honor.
State?
Yes, Your Honor.
State, on display is a document entitled State's Consent to Video Conferencing. Did you sign this document that's consenting to these proceedings by video conferencing?
Your Honor, ADA Ling signed this document, but I adopt her signature as my own. Yes, Your Honor, the state has signed.
State's video conferencing consent is made part of the record. Counsel, defense, on display is a document entitled Defendant's Consent to Video Conferencing. Mr. Lejean, is this your signature where I'm circling the cursor?
Yes, ma'am.
Did you sign this document that's consenting to plea by video conferencing?
Yes, ma'am.
With your signature on the same document, counsel, do you join your client in consenting to these proceedings by video conferencing?
Yes, Your Honor.
The defendant's video conferencing consent is made part of the record. Counsel, how long have you represented Mr. Lejean?
Since about October 2021.
And we're applying for probation, and if so, what type?
Deferred adjudication, Your Honor.
Mr. Lejean, I draw your attention to the document on display. It's entitled Application for Deferred Adjudication Community Supervision. This is a 2-page document, this being the first and then this being the second. I draw your attention to the area I am circling on page 2 of this document. It says that you are the person that you personally appeared before me today, albeit via Zoom. You are the person or the defendant in this case, and you have been duly sworn in. Under oath, you're going to tell me that your application for deferred adjudication community supervision and the document entitled personnel data sheet, which is going to be attached as an exhibit to your application, is true and correct. Keep in mind that if it's not completely filled in, it cannot be true and correct. I'm going to share with you your personal data sheet. Please just point out to me if there's anything that is missing or needs to be added.
Yes, ma'am. No, ma'am, that looks correct.
Sir, do you need to speak to your attorney before responding to this statement?
No, ma'am.
That the defendant understands and acknowledges that any untrue statement in the application or the exhibit, the personal data sheet, may be grounds for denial or revocation of any community supervision in this case. Do you need to speak to your attorney to understand the consequences of your response to that statement?
No, ma'am.
And so what is your response? Do you understand and so acknowledge?
Yes, ma'am.
I will sign the document, making it part of the record. State, have you fulfilled your discovery and Brady requirement in this case?
Yes, Your Honor.
And counsel, are you satisfied that the state has fulfilled its obligation to provide you discovery under Article 39.14 of the Texas Code of Criminal Procedure, as well as giving you full access to the state's files?
Yes, Your Honor.
State, is this matter subject to law enforcement disclosure? And if it is, has it been complied with?
Yes, Your Honor, this is subject to that. The offense date is October 2nd of 2021, and the state has complied.
I will sign the discovery acknowledgement, making it part of the record. State, do you have any motions for the court's consideration at this time?
Yes, Your Honor, the state would move to waive the 0.15 enhancement and proceed on a DWI first, a Class B misdemeanor.
No objection, Your Honor.
Without objection, that state's motion is granted. State, do you have any further motions for the court's consideration?
No, Your Honor.
Defense, do you?
No, Your Honor.
Mr. Lejean, I draw your attention to a document on display. It's entitled Defendant's Waiver of Constitutional Rights and the Court's Admonitions. This is a 2-page document. This is the first page, and then this is the second page, sir. Is this your signature where I'm circling the cursor on the second page here?
Yes, ma'am.
Did you go over this document with your attorney?
Yes, ma'am.
After you reviewed it with your attorney, did you freely and voluntarily sign the document?
Yes, ma'am.
So with your signature and your testimony now, you're telling me that you understand everything in this 2-page document as it was reviewed and explained to you by your attorney.
Yes, ma'am.
Are you satisfied with the representation of your attorney?
Yes, ma'am.
Well, you see how she is a very good attorney. She has been able to reduce this from a Class A to a Class B misdemeanor for starts and remove the 0.15 enhancement, making it just a DWI first. With that, do you understand the range of punishment? She explained to you the new range of punishment in this case, right?
Yes, ma'am.
Do you understand your constitutional rights?
Yes, ma'am.
With that understanding, do you freely and voluntarily give them up?
Yes, ma'am.
So giving up your constitutional rights, sir, are you a citizen of the United States?
Yes, ma'am.
I will approve your jury waiver. I am going to sign it, make it part of the record. You will no longer be able to have a trial in this case. Counsel, do you believe that your client is competent to enter into a plea today?
Yes, Your Honor.
With the information, were you able to apprise this defendant of the nature of the offense and the charges against him?
Yes, Your Honor.
Do you and this defendant waive the formal reading of the information?
Yes, Your Honor.
State, what is the punishment recommendation in this case?
Yes, Your Honor, the recommendation is a $250 fine with court costs, 24 months deferred adjudication, DWI education course, victim impact panel, 48 hours of community service, ignition interlock for half the term, restitution, if any, to be determined by CSCD, to be made to Diana Smith, DIANA, Smith, SMITH.
Counsel, is that your understanding of the state's punishment recommendation?
It is, Your Honor. I would like to be heard on the ignition interlock, however.
Okay, thank you. I will give you that opportunity. Mr. Lejeune, is that your understanding thus far as what your attorney has worked out with the state on your behalf in order to dispose of this matter for you today?
Yes.
With that understanding, how do you wish to plea? Guilty, not guilty, or no contest?
No contest.
Sir, do you understand that even though you are pleading no contest, I can still find you guilty
Yes, ma'am.
and you still wish to proceed?
Yes, ma'am.
Now, you've discussed this entire matter with your attorney,
Yes, ma'am.
and you are telling me with your plea of no contest that you do not wish to fight any of the charges in this case?
Yes, ma'am.
And after discussing with your attorney, with your plea of no contest, you believe that that's in your best interest?
Yes, ma'am.
I will accept your plea of no contest, finding that it is intelligently and freely made and that you are competent to enter into such a plea. Counsel, what, if any, do you wish to say about your client and why I should consider this plea? And also you mentioned that you wanted to address the court regarding the ignition interlock.
Yes, Your Honor. I'll first address the ignition interlock. My client does not have a car and does not drive, and he has been doing, I believe it's the where he reports and does a UA there and or a home breathalyzer. So I would ask that in lieu of the ignition interlock, that you allow him to do the, I guess it's weekly or every other week, where he goes in and gives a UA. I'm not sure if that's what it's called. The DTS, is that what it is? I'm not sure. Or in-home breathalyzer.
Let me just double check something for you, counsel. Give me 2 seconds, please.
Yes, ma'am.
Yes, counsel, I believe on the 2nd of May, we were able to go ahead and address a couple of violations, specifically for non-enrollment with the ignition interlock. He was ordered to do that. And so at that time, we did allow him to be going ahead and taking the UAs. However, with the probation, he'll need to go ahead and get on a portable alcohol monitoring device.
All right. Yes, Your Honor.
Mhm.
And
And did he provide, with that, counsel, did he provide the appropriate affidavits of non-ownership with an explanation on what happened to this vehicle, the vehicle involved in this incident?
I think he might have, Your Honor, but if he needs to do something further, we can make sure he gets that done.
Okay. I believe since it may have been provided to pretrial, he'll need to go ahead and provide it to probation.
Okay.
Mhm.
And but we'd ask that you follow the plea bargain, Your Honor, and he's a young man, and ask that you allow him to do this. He's been on pretrial for quite a long time, and we're just asking that you allow him to be placed on probation with the conditions that the state and I have discussed.
State. Any objections regarding portable alcohol monitoring device?
No objections, Your Honor, as long as a non-driving affidavit is provided.
State, what was the BAC in this case?
1 second, Your Honor. Your Honor, it is a 0.16.
Sir, your work at with Toyota does not involve driving a vehicle or testing a vehicle, anything of that nature, sir?
No, ma'am.
Whom do you live with?
It's me and my roommate.
Whom?
It's just me and my roommate.
Okay. Does your roommate have a vehicle?
Yes, ma'am.
What's your roommate's name?
Donald Holden.
Spell that last name for me, please.
Holdan.
Okay. State, do you have any objections to referral of this defendant to the Bear County Gives Back program?
No objections, Your Honor.
Counsel, is there any legal reason why this matter cannot be disposed of today?
No, Your Honor.
Mr. Lejeune, although there's sufficient evidence to find you guilty in this case, I'm going to withhold my finding of guilt. And I'm going to place you on 24 months of deferred adjudication probation. Community supervision probation for DWI first. You will be monitored and supervised on behalf of this court by the Community Supervision and Corrections Department, otherwise known as the Probation Office. For this, with these following conditions: $250 fine plus court costs, DWI education, victim impact panel, uimpact.com, and TAP evaluation. 48 hours of community service restitution. I'm going to refer you to Bear County Gives Back program for satisfaction of the first 40 hours of the community service restitution.
Yes, ma'am.
Ignition interlock for half the term. However, because we have addressed this issue before, there's going to be a portable alcohol monitoring device. You will continue, and that needs to be installed within within 10 days, 10 calendar days. Restitution, if any, to Diana Smith could be determined by the Community Supervision and Corrections Department. I'm going to require 3 affidavits from you within 10 calendar days. You can combine 2 of them in one document if you like. 1 from you or 2 from you that you will not drive any vehicle that's not equipped with an ignition interlock. Excuse me. And then another from you that's titled non-ownership, non-driving, with you providing status of the vehicle that was involved in this incident. Identify that vehicle by year, make, model, color, and ignition, license plate, and the last 6 digits of the vehicle identification number. Who owned that vehicle that you were driving?
I did.
And your relationship to whoever owned that vehicle.
Okay, yes.
And a third, and if the status is that it has been impounded or destroyed by, or is irreparable, I'll need third-party verification of the current status. Donald, I'll need an affidavit from Donald Holden, whom you have identified to be your roommate, whom you live with, and has a vehicle. He will, and his affidavit is that he will not give you any permission to bring, now he will not allow you to drive his vehicle under any circumstances. Otherwise, I'll have to put an ignition interlock on that because you do have access to it. And I need that vehicle also identified by year, make, model, license plate number, and the last 6 digits of the vehicle identification number. I will have the community supervision officer to provide a status report on how well you're doing on probation in 2 months and conduct a field visit. I'm going to set your supervision fee at $45. State, did I cover everything for you?
Yes, Your Honor, thank you.
Counsel, anything further on this matter?
No, Your Honor.
I am going, Mr. Lejean, regarding the trial court certification of defendant's right to appeal, I am going to certify that you have no right to appeal. Because this has been a plea bargain case. I'm signing it. Now you'll be able to get a copy of this document when you come down to provide us your fingerprints. When will you be able to do that? Monday, Tuesday, or Wednesday?
Monday.
Sorry, on Monday, you'll be coming down to County Court at Law Number 2, located at 300 Dolorosa, San Antonio, Texas, 78205. You'll be coming down between the hours of 2 p.m. and before 4:30 p.m. Now understand that if you do not show up on Monday, a warrant will be issued for your arrest. Do you understand that, sir?
Yes, ma'am.
With regard to the Bexar County Gives Back program, I'm going to put you in a breakout room with the court liaison officer to explain all that to you and to determine if you're eligible to participate in that program. Again, it's an alternative that I provide to satisfy the community service restitution requirement. You don't have to participate in it if you don't want to. You're still responsible for the 48 hours of community service restitution.
Yes, ma'am.
Now, your attorney has worked very hard for you. The way for you to appreciate the hard work your attorney has done for you, sir, is to be successful on probation. You have a long life ahead of you. You are already contributing to the community and the betterment of San Antonio with your hard work over there at Toyota. wish for you to go ahead and continue that, sir. And if the 24 months, though, is a long time to be being on probation. So if there's anything that we can do to help you be successful, because I'm looking for you to be successful, sir, please let us know through the community supervision officer, okay?
Yes, ma'am. Thank you.
All right, well, thank you so much. You hang on, we'll put you in the breakout room, and then from there you'll be excused and we'll see you on Monday. Counsel, did you wish to go in the breakout room with him as well?
Not at this time, Your Honor. I'll talk to him later. May I be excused?
Yes, counsel, have a great weekend. Thank
All
you
right,
again for
you
your
too.
time. All righty.
Bye-bye.
All right, Officer Jennings, I need to go ahead and address a couple of matters, and then you can join Mr. Lejon, okay?
Okay.
All righty. Okay. Okay. All righty. Okay. Thanks.
So he's supposed to, he can stay.
Let state, let me stop sharing here. State, we're going to get on record. You have cause number 681682.
Yes, Judge, but ADA Moses is going to take over. May I be excused, Your Honor?
Thank you very much for all your help. Appreciate it.
Thank you, Judge. Have a good
Have
afternoon.
a great weekend.
You too, Your Honor. Thank you.
Good to see you.
You as well, Judge.
Yes, Judge, I have that case pulled up.
Thank you. Okay. And 2 seconds. Attorney Guerrero.
I am present, Your Honor.
Good afternoon. And ma'am, do I need to put you in a breakout room with your client, with Ms. Garcia?
No, she has been reporting to your court. She had reported to me she was going to hire Miss Carolyn Wentland. I don't believe that has come to fruition. I was informed by Miss Luna to come here to continue to represent her, and now I am present.
Okay. When I talked to her this morning, I asked her who her attorney was. She stated your name. So I was just trying to figure that out because she's been trying to hire someone she's been saying that she's going to hire someone. That person hasn't shown up. Who is your attorney now? Please approach. Yes. Okay. Are you Ana Maria Garcia?
Yes, ma'am.
Who is your attorney?
Monica Guerrero.
Counsel, do you need to have a conversation?
No, Judge, I'm just going to ask for a brief reset so that we can get on the same page as to what approach she wants to take in this case.
would appreciate it because you guys were ready to plead this case several weeks ago, and then she started saying that she wishes to go ahead and, I've heard the name, Carolyn Whitland.
Yes, ma'am.
Okay, so we need to go ahead and get the cases set up.
Yes, ma'am.
Okay, all righty. So council, what are we looking at next week?
Whenever day you want to set it, Judge. I am set for trial Monday and Tuesday in impact court, but if your court tells me I can ask Mr. Stateston to show up.
Sure, we can do next Friday, the 12th.
Thank
Or
you. That would be
Monday,
a
the
great date.
15th.
The 12th would
Oh,
be
I'm sorry.
perfect.
It would, or we can
Yes.
do the 15th.
The 12th would be the best.
All right. Okay, so we're going to plead this case on the 12th,
Yes, ma'am.
but you're gonna get with them and
Yes,
talk to
ma'am.
them about it, okay?
Yes, ma'am.
All righty, very good. All righty. Counsel, if it's okay with you, I'm going to just have her get a case reset form, and we'll see you guys on the 12th.
Thank you, Your Honor. I appreciate your help.
Okay, thank
Ms.
you.
Guerrero. Thank you, Your Honor.
You just sit tight right there. Miss Luna will come and give you a case reset
Yes,
form.
May I
Okay.
be excused?
Yes, ma'am. Have a great weekend.
Thank you, Your Honor.
Okay. Okay, let's get, oh, excuse me. I have a director here. How you doing, sir? Good. Please approach. No, not a problem. How you doing? Good. Okay. I don't know. Could you give me a second so that we can, you have time? Thank you so much. Let me get it. Okay. Let's get on record on cause number 681682, State of Texas versus Luis Mauricio Blanco. Parties, please approach and identify who's before the court, starting with the state.
Brett Bosis for the state.
Raymond Martinez from Mr. Blanco.
Hello.
Ashley Jennings, Court Liaison Officer for County Court at Law Number 2.
And are you Luis Mauricio Blanco?
Yes, ma'am.
Mauricio. And it's Mauricio, correct?
Yes, ma'am.
Okay. What is that feedback, sir? Sir, there's noise and feedback coming from you, Mr. Blanco.
I think there's a fan behind him, Judge.
Yeah, there's a little fan right next to me.
Just go ahead and turn it off, Mr. Blanco.
Alrighty. Is that better?
Much better. Thank you so much.
No problem.
You too. Are you the same Luis
Yes, ma'am.
Mauricio Blanco that was placed on probation on the 16th of May, 2022 for unlawful carry of a weapon and for a period of 8 months? Are you the same Luis Mauricio Blanco?
Yes, ma'am.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing else but the truth under pains and penalties of perjury, so help you God?
Yes.
All right, thank you. You may go ahead and lower your hand. And counsel, how long have you represented Mr. Blanco?
For months, Your Honor.
And counsel, do you believe that your client is competent to proceed today?
I am, Judge, but it was my understanding the state was going to withdraw the motion.
Okay. And state, so turn it to state.
Yes, Judge.
Okay. From the last time that I heard this matter was going set for a contested hearing for today. And so what are we, that's what my understanding is, counsel. This was going to be a contested hearing. So what has happened? State?
Well, Judge, I'm not sure what happened. It was not the state's intention to move forward and revoke this defendant's probation. So what defense said is correct. The state was going to withdraw the motion to revoke.
Okay. And has that motion been filed?
The motion to withdraw?
To yes.
I don't think it's been filed yet.
Let me see. I have it.
Your Honor, it was sent this morning to you. Lane signed it, and then we're just waiting on your signature.
Let me see.
Okay.
How has Mr. Blanco been doing while on probation?
Okay, his original conditions to complete were 40 hours of community service hours. He completed 12 hours. He has a remaining of 28 hours. He was supposed to attend and complete a high school GED program. He has not yet completed that. A gun safety course was completed on July 9th, 2022. No possession of a firearm for probation term and 5 searches per week until employed. On July 18th, 2022, probation reported, and he stated to his CSO that he quit at Papa's employment. On July 14th, 2022, he reported he is searching for a job as of today. Mr. Blanco fees assessed were $863, and he has paid $495 and is current. Probation recommendation is to extend 3 months, amend conditions for supportive outpatient treatment, cognitive behavior program, monthly drug testing, and sober support meetings once a month for 90 days.
repeat those recommendations to me again?
Recommendation is to extend 3 months, amend conditions for supportive outpatient treatment, cognitive behavior program, monthly drug testing, and sober support meetings once a month for 90 days.
How many hours of the community service hours has he completed?
He has completed 12 hours, Your Honor.
Of 40?
40 hours, correct.
And I do have state's motion to withdraw the motion to adjudicate probation. He is on deferred adjudication, correct?
Correct.
All righty. Defense, anything?
Judge, we would object to any amendments of his probation in light of the fact that there's no pleadings before the court for revocation or adjudication.
And what is the defense's argument thus then?
Judge, in order to get the probationer before the court, they filed a motion to adjudicate, but they've now sought to withdraw that, which I'm assuming the court's going to grant. So I'm not sure there's a basis for a sua sponte modification of his conditions of probation without any pleadings or any matter before the court.
Well, counsel, the thing about it is that the court supervises this defendant and he has not performed his the requirements of his community supervision. So therefore, the court does, if he has not satisfied those requirements, the court can go ahead and modify those requirements to be able to ensure that he completes his community supervision successfully, and he has not been able to do that.
I'm sorry, Judge, I might have misunderstood. I thought the CLO said that he was current in terms of several of his conditions. I agree that he hasn't completed them all, Judge, but he still has a number of months to go.
And when does this probation end?
It expires January 15, 2023.
Okay, and so let's go ahead and reset this matter. He's now doing the job searches that was ordered, and that needs to be documented, and the Texas Workforce Community Job Search Log, as it was previously ordered. The GED. Continue with the fees, payment of the fees. And then set him up for a performance review hearing in 30 days.
Okay.
Judge, in light of the fact that the state's withdrawn their motion, can I be excused from that hearing? Since I'm not going to be retained on the performance review matter.
Yes, sir. That's between you and as far as the defendant is concerned, but that's between you and him. I'm going to order a performance review hearing in 30 days to see how he's doing.
Understood, Judge. I just didn't want to run afoul of the court for not appearing.
And you are continuing to go ahead, you will continue to go ahead and are you and him? Right? As what is said right now. So continue with the UAs, continue with all the conditions of probation for him to be able to work towards completion of his probation successfully, all his conditions, okay?
Okay.
And I am going to go ahead and sign the state's motion to withdraw, and we'll see you in 30 days, Mr. Blanco.
Do you have a specific date for that, Judge?
No, the CLO will go ahead and
Okay.
make that happen. And he'll be informed and get a case setting from his CSO.
Okay, perfect. Thank you, Judge.
Thank you. And anything further on this matter? State?
No, nothing further from the state, Judge.
And anything further, counsel?
No, Your Honor, thank you.
All righty. You and your client are excused, and CLO, if you will go ahead and jump in that breakout room for the last person with Mr. Lejean.
Okay, thank you.
Thank you. Attorney Cuellar, are we ready to, are you ready to go ahead and for your case?
Yes, Your Honor.
Do I have a personal data sheet to review? It's once completed.
Judge, the defendant submitted a personal data sheet through email and I went ahead and forwarded that to you.
Okay, thank you. Attorney Cuellar, this is what I have.
I
Judge,
was,
there's two attachments on the email.
Yes, correct. This is a PDF. Let's see. Sorry, I will not be able to use the other one. Okay, the other one is that camera. Alrighty, so send them an Adobe fill, or state, can you send them Adobe sign document? Mr. Lejean, do you have anything else in this court?
I'm currently still waiting to go to the breakout room.
Oh, okay. Accept your invitation, sir.
I haven't received one.
CLO.
She's no longer in here. Oh, I got it. Thank you.
Okay, state, will you be able to send the attorney that Adobe sign for the personnel data sheet?
Yes, I can do that now.
Okay, thanks.
Okay, that personal data sheet has been sent out.
Your Honor. You can approach, Your Honor.
Attorney Cuellar, how are we doing with that personal data sheet, sir?
Your Honor, I received it and I have it here. I guess I can fill it out. But I probably need to go into a breakout room with my client for the information. And there's also a click signature there. I'm assuming that's for her. So I'm not sure how we're gonna do that.
Okay. I can also go ahead and send it to her.
Okay. Might be-
Or was, I think it's sent, it can be sent to her too. They didn't have the email address. Could you move him in the breakout room with his client? Yes, and it is the Montserrat Pimentel. Attorney Cuellar and Montserrat Pimentel.
Thank you.
Yes, sir. For those who came back just a little bit early for the civil matters, I've just got one more case to take care of, criminal case, and then I'll be with you guys, okay? Appreciate your patience. Recess 5 minutes. Attorney Cuellar, are we ready to proceed? Oh, Attorney Cuellar, if you're speaking, you're muted.
Your Honor, can you hear me?
Yes.
I apologize. I've had a lot of trouble today with my. I believe we should be ready.
Yes, sir. Thank you. Let's get on record. The court is going to call cause number 682-157, State of Texas versus Monserrat Andrea Pimentel. Parties, please approach and identify who's before the court, starting with the state.
Brett Bosis for the state.
And David Cuellar for Ms. Pimentel.
Are you Monserrat Andrea Pimentel? Please unmute and respond.
Yes, I am, Your Honor.
Are you the same that's been accused of driving while intoxicated, alleged to have occurred on the first day of April 2022 and classified as a Class B misdemeanor?
Yes, ma'am.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing else but the truth on the pains and penalties of perjury? So help you God.
I do.
All righty, thank you. You may go ahead and lower your hand. Court is going to start sharing the court screen. Ms. Pimentel, can you see the court screen?
Yes, I can.
Counsel, can you see the court screen?
Yes, you can, Your Honor.
And State, can you see the court screen?
Yes, I can, Judge.
State, on display is a document entitled State's Consent to Video Conferencing. Did you sign that document that's consenting to these proceedings by video conferencing?
ADA Han signed these documents, but yes, the state does consent.
State's video conferencing consent is made part of the record. Defense, on display is the document entitled Defendant's Consent to Video Conferencing. Ms. Pimentel, is this your signature where I'm circling the cursor?
Yes, ma'am.
Did you sign this document that's consenting to plea by video conferencing?
Yes, ma'am.
Defense, with your signature on the same document, are you joining your client in consenting to these proceedings by video conferencing?
Yes, I am, Your Honor.
Defendant's video conferencing consent is made part of the record. Counsel, how long have you been representing Ms. Pimentel?
In over 10 days, Your Honor.
Are we applying for probation, and if so, what type?
Yes, deferred adjudication on an obstruction, Your Honor.
Ms. Pimentel, I draw your attention to a document entitled on display and entitled Application for Deferred Adjudication Community Supervision. This is a 2-page document, this being the first, and then this is the second page. I draw your attention to where I am circling this cursor on the second page, whereby it states that you have appeared before me, albeit via Zoom. You are the defendant in this case, and you have been sworn in. Under oath, you're going to tell me that your application for deferred adjudication community supervision and the document entitled your personal data sheet, which is going to be attached as an exhibit to your application, is true and correct. I'm going to share with you your personal data sheet. Please just let me know what information needs to be corrected or added in, and keeping in mind that if it's not completely filled in, it cannot be true and correct. Any information that you need to go ahead and correct or?
Not at this time, Your Honor.
Ms. Pimentel?
No, ma'am.
Do you need to go ahead and discuss with your attorney to understand the consequences of your response to this statement, that the defendant understands and acknowledges that any untrue statement in the application or in the exhibit, your personal data sheet, may be grounds for denial or revocation of any community supervision in this case? Do you need to speak with your attorney? Ms. Pimentel, it would be easier if you unmute yourself and stay unmuted so we can complete this plea. Okay, unmute yourself and respond, please.
No, ma'am.
And so what is your response? Do you understand and so acknowledge?
Yes, I do.
Thank you. I will sign the document and make it part of the record. State, have you fulfilled your Brady and discovery requirement in this case?
Yes, we have, Judge.
Defense, are you satisfied that the state has fulfilled its obligation to provide you discovery under Article 39.14 of the Texas Code of Criminal Procedure, as well as giving you full access to the state's files?
Yes, Your Honor, I am satisfied.
State, is this matter subject to law enforcement disclosure? And if it is, has that been complied with?
Yes, it is, Judge, and it has been complied with.
Thank you, State. I will sign the discovery acknowledgement, making it part of the record. State, do you have any motions for the court's consideration at this time?
Yes, Judge. One moment. Judge, the state would move to waive and abandon count 1, and we will proceed solely on count 2, obstruction of a highway.
No objection to that, Your Honor.
Without objection from defense, state's motion is granted. Any other motions for the court's consideration at this time, State?
Yes, Judge, we would also move to enter Exhibit 1 into evidence for the purposes of this hearing.
And Exhibit 1 is at the bottom?
Yes, it is, Your Honor.
Okay. Sorry, I don't know why this just keeps bouncing back. State, is this State's Exhibit 1?
Yes, it is, Judge.
All righty. What say ye, defense?
No objection, Your Honor.
State's Exhibit 1 without objection from the defense is admitted. Ms. Pimentel, this is State's Exhibit number 1. It's a package of documents The first document is stipulation of facts and judicial confession. And this is that's the first document. The next document is motor vehicles in the household, whereby it states here that you hereby swear that the following motor vehicles are possessed or owned by you or a member of your family or household where you live. And the court notes that one vehicle has been identified, and you signed this document. The next document is the plea bargain sheet. Next document is a waiver of appeal and post-conviction remedies. The next document is the oath. Again, it states that you are the person who appeared before me, that you are the defendant in this case. I have sworn you in, and you are stating that all the facts stated in the above stipulations and plea agreement are true and correct, specifically including these documents that I have shown you and read to you. You have signed that. I am going to sign it, and I have signed it. Now, over here, I'm going to order the admission of these documents. It indicates here that you tend to plead guilty. I shall so order. State, do you have any other motions for the court's consideration at this time?
No further motions from the state.
Defense, do you have any motions for the court's consideration?
No, Your Honor.
Ms. Pimentel, on this split, I am sorry about this thing, just jumping back and forth. Ms. Pimentel, on displays document entitled Defendant's Waiver of Constitutional Rights and Course Admonitions. It's a two-page document. This is the first page, and this is the second page. Is this your signature on the second page where I'm circling the cursor?
Yes, ma'am, it is.
Did you review this document, two-page document, with your attorney?
Mm-hmm. Yes, ma'am.
And after reviewing it with your attorney, did you freely and voluntarily sign it?
Yes, ma'am.
So with your signature and your testimony now, you're telling me that you understand everything in this two-page document as it was reviewed and explained to you by your attorney?
Yes, ma'am.
And you're satisfied with the representation of your attorney?
Yes, ma'am.
He has done very well to pick up this case and bring it to to be able to go ahead and bring it to resolution for you. As you have seen, he has worked very hard to be able to bring this from a DWI, and now it's an obstruction. And furthermore, it's a regular Class B misdemeanor. He went over with you the range of punishment in this case, right?
Yes, ma'am.
And you understand it?
Yes, I do.
And do you understand your constitutional rights?
Yes, ma'am.
Understanding your constitutional rights, do you freely and voluntarily give them up? Ms. Pimentel, did you understand my question? Do you freely and voluntarily give up your constitutional rights?
Yes, ma'am.
Okay. Are you a U.S. citizen?
Yes, I am.
I will approve your jury waiver, and I will sign the document, and now make it part of the record. You will no longer be able to have a jury trial in this case. Counsel, do you believe that your client is confident to enter into a plea today?
Yes, Your Honor. Definitely.
With the information, were you able to apprise this defendant of the nature of the offense and charges against her?
Yes, Your Honor.
Do you and this defendant waive the formal reading of the information at this time?
Yes, we did, Your Honor.
State, what is your punishment recommendation?
Judge, the state's punishment recommendation is for 18 months of deferred adjudication probation, $500 fine, plus court costs, 48 hours community service, the DWI education class, the U-Impact class, TAIP evaluation, and ignition interlock for half the term of probation.
Counsel, is that your understanding of the state's punishment recommendation to the court?
Yes, Your Honor.
And Ms. Pimentel, is that your understanding of what your attorney has worked out for you with the state? And
Yes,
to be able to go ahead and dispose of this matter today?
Yes, ma'am.
With that understanding, how do you wish to plead? Guilty, not guilty, or no contest?
No contest.
State defense, there's a couple of incongruent things here. Okay, here this document says no contest. The defendant has pled no contest, but in the obstruction paperwork, it states here clearly it's going to be guilty, that they intend to plead guilty. And I mean, as I stated on the record, what do we want to do?
Judge, it's fine with the state to amend the guilty on the obstruction paperwork to reflect no contest.
Defense?
I don't have any objection to that.
No objection, Your Honor.
So with your permission, once this document is printed, I can go ahead and make that change, make this correction here?
Yes, Judge.
Defense?
Yes, Your Honor.
Thank you both. So Ms. Pimentel, do you understand that even though you're pleading no contest, I can still find you guilty?
Yes, ma'am.
And you still wish to proceed?
Yes, ma'am.
You've discussed this matter with your attorney? If it does, discuss the entire matter with your attorney, correct? Entire case?
Yes.
And so with your plea of no contest, you're telling this court that you do not wish to fight any of the charges in this case?
No, ma'am, I don't.
No, you do not wish to fight the charges.
That is correct.
And with your plea of no contest, you believe that is in your best interest?
Yes, ma'am.
I will accept your plea of no contest. I will find that you are competent to enter into such a plea and that you are, and you do so freely and intelligently. Counsel, what, if anything, do you have on behalf of your client? And why should I consider this plea?
Your Honor, my client is, she's quite young still, and she realizes the consequences of her actions, and I know she's going to do her very best. to complete all the terms, and she's here accepting these terms. She's not fighting it, and I think she'll do well. I think she'll become a very productive member of society, Your Honor.
Thank you, counsel. That really does help. Ms. Cuellar, excuse me. Ms. Pimentel, whom do you live with?
My parents.
Do they both have cars?
Yes, ma'am.
What are their names?
Nina and Jorge Pimentel.
They each have a car each?
Yes, ma'am.
How many cars are in the household?
Just one, mine.
I thought you just told me that you live with your parents.
Yes, I do.
Okay, so do you consider them now part of your household where you live?
Oh, yeah, it would be 3.
And you do consider them to be family?
Yes, ma'am.
And so when you filled out this document, and I read to you exactly what it says, that's owned by you or a member of your family or household where you live, you only listed one vehicle. Think you should have listed both your parents' vehicles?
No, I was just confused by the question. I was just under a lot of pressure signing all of these, so I just put my name, but I have my parents' cards information if I can go ahead and insert that in any way.
Your Honor, I would also like to add that she told me, I think this is where some of the confusion came from. She told me she has no access at all to her parents' vehicle. So this is the only vehicle she has access to. But she can certainly add the other information.
Not a problem, counsel. That the statement here is the vehicles are not possessed or owned by me or a member of my family or household where I live. That is, it does not contemplate access or not. It's just number of vehicles in the household. So that's okay. Ms. Pimentel, you can go ahead and be able to complete this information when you come down. You say you have the information, correct?
Yes, I do.
It's just by your reaction, it seems like you just understood it and that you were not trying to misrepresent to the court, were you?
No, I was honestly just confused. I'm sorry. I apologize.
Not a problem, man. Do you have the ignition interlock installed in your vehicle at this time?
No, I do not.
Okay, just okay.
I don't have a driver's license, so I didn't think I had to. since I'm not driving anywhere.
State, what was the BAC in this case?
One moment, Judge.
While you're looking for that, Ms. Pimentel, could you describe to me by year, make, model, and color of the vehicle that will be putting the ignition interlock on? Did you hear me, Ms. Pimentel?
Yes, ma'am. Did you not hear me? I'm sorry.
No, you were muted.
Oh, okay. I apologize. It's a Toyota Camry 2015 colored gray.
And Judge, the BAC in this case was a 0.13.
Thank you, State. State, was there an accident in this case?
I can find out in just a second. No, Judge, no accident.
State, do you have any objections for this, to this defendant being referred to the Bear County Gives Back program?
No objection from the state.
Counsel, you're familiar with the program?
I've heard of it, Your Honor. The details kind of slip by me right now.
Okay. Defense, is there any legal reason why this matter cannot be disposed of today?
No, Your Honor.
Ms. Pimentel, although there's sufficient evidence to find you guilty in this case, I'm going to withhold my finding of guilt, and I'm going to place you on 18 months of deferred adjudication, community supervision, probation for obstruction of highway. You will be supervised and monitored by the Community Supervision and Corrections Department, otherwise known as Probation Office. On behalf of this court, with the following conditions: $500 fine plus court costs, 48 hours of community service restitution. I will refer you to the Bear County Gives Back program for satisfaction of 40 hours out of the 48 hours. You can participate in that program if you wish. My CLO will go ahead and explain that to you and see if you're eligible. If you do not wish to participate in it, you're still responsible for the full 48 hours, and it's only be counted for only 40 hours of the 48 hours. Also, the DWI education, uimpact.com. tap evaluation, ignition interlock for half the term of probation, and you will have that installed in 10 calendar days. I will need 2 affidavits from you within 10 calendar days. One from you that you will not drive any vehicle that's not equipped with an ignition interlock. The second one will be from Nina and Jorge Pimentel, can be on the same document, whom you have identified as your parents who own 2 vehicles and whom you live with in the same household. And that is, they will not allow you to drive their vehicle under any circumstances. Otherwise, I will have to order ignition interlock to be placed on those vehicles. You will identify those vehicles by year, make, model, color, license plate number, and last 6 digits of the vehicle identification number. I will have your community supervision officer provide a status report on how well you're doing on probation. Provide that status report in 2 months, and will have provided me will have conducted a field visit. I'm also going to set your supervision fee at $40. State, did I cover everything for you?
Yes, you did, Judge.
Counsel, anything further in this matter?
I think that covers everything. We have nothing further, Your Honor.
Ms. Pimentel, although with regard to the trial court certification of defendant's right of appeal, this has been a plea bargain case, and I'm going to certify that you have no right to appeal. You will get a copy of this when you come down to provide us your fingerprints. Now, when would you be able to do that? Would you Monday, Tuesday, or Wednesday?
I can show up Monday.
All righty. Now, Monday, you'll be coming down to County Court at Law Number 2, located at 300 Dolorosa, San Antonio, Texas, 78205 is the zip code. We're on the first floor of the Cadena Reeves Justice Center. When you come in, just go ahead and check in with the deputy, and he'll give you further directions. You'll need to come between the hours of 2 p.m. and before 4:30 p.m. If you do not show up, Ms. Pimentel, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am, I do.
I look forward to you being very, very successful while you are on probation. Your attorney has said a lot of good things about you, and he has worked hard for you. The way for you to appreciate all the hard work he has done for you is for you to be successful. I'm looking for you to be successful. 18 months is a long time to be under scrutiny. So if there's anything that we can do to help you be successful, please make sure to communicate that to your probation officer, okay?
Yes, ma'am.
All righty, continue the good work that you're doing in society, okay?
Mm-hmm.
This is just a short bump, a bump in the road for you. Let me go ahead now. We're off record on this matter. Put you in the breakout room with the court liaison officer. And counsel, I'll move you in there with her as well. Please go ahead and put them. Thank you, counsel. And you guys are excused from there, okay?
Okay, thank you, Your Honor.
Thank you.
Yes, thank you very much. Thank you, counsel. You guys have a great weekend.
Thank you. You as well.
Mhm. State, I believe that takes care of it. Officer Jennings, once you're done, have a great evening, okay? Thank you.
You too. Thank you.
There's maybe a couple of things I need to discuss with you, but let me know. Okay?
Okay.
All righty. Who is? Attorney Stricker and Ms. Danielle Walker, I do expect for this to take less than 5 minutes. You're going to need to go ahead and provide me a couple of, just about 3 dates, right? So
Yes,
let's
Judge,
get on
that's correct.
record. Okay, let's go ahead and get on record on cause numbers. 2022 CV 02439, 2022 CV 02440, and 2022 CV 02441. This is the matter of Danielle Walker versus Regency Property Management. Parties, please approach and identify who is before the court, starting with the plaintiff. Is Danielle Walker plaintiff and Regency Property Management defendant?
I'm here, Your Honor. Danielle Walker. Can you hear me?
Yes, Judge Les Stricker, here on behalf of the defendant.
Okay.
Can you hear me, Your Honor?
Yes, I heard you. Thank you
Okay.
so much for identifying. We had spoke a little bit earlier. I believe that we're here for this matter was scheduled for a bench trial. Is that correct, Ms. Walker?
Yes, Your Honor. I was okay with that.
Okay. But in discussion earlier, and counsel, some of the discussion, some of the information that we shared and discussed earlier, we have come up with the fact that you're going to provide me 3 pieces of information now, dates. One for mediation. I hope you were able to get a hold of their County Dispute Resolution Center.
Yes, ma'am.
That's, you've agreed to these matters being consolidated, and you're going to give me a date where you're going to narrow the issues and claims so that we'll just, we'll be able to go ahead and narrow that, and then a date for a trial. So I need 3 dates from you, correct? Counsel, is that your understanding?
Yes, Your Honor, that is correct.
And that's your understanding, right, Ms. Walker, plaintiff?
All except for one, Your Honor. That's what I wanted to ask you about clarification.
Alrighty.
It was about the date for the consolidating. Again, I just maybe wasn't quite understanding exactly what you meant by that, because I had, as soon as you said it, I did consolidate it. Did you mean that do I have to refile something for you or for the court?
I thought that you were going to talk with, you did have a chance to talk with Attorney Stricker.
Yes, ma'am, I did.
Okay.
And we
you
did
were
have-
in
we do have a date.
agreement of consolidation.
Yes, ma'am.
Okay. So whatever that has to happen and how that has to happen, that's between the 2 of you to go ahead and figure out. Okay. Right now, what I need is a date for you guys to come back and tell me that it's all consolidated, it's done, and what the issues that we're going to go to trial on are.
Great. Yes, ma'am.
That's the narrowing of the issues and the claims, okay?
Yes, ma'am.
You did have that discussion, Attorney
Yes.
Stryker?
Yes, Judge. Yes, Judge. Yes, we did discuss the consolidating of these claims that are now in 3 cause numbers into 1. I attempted to confer with Ms. Walker on that subject. And Your Honor, I mean, all due respect to Ms. Walker, I tried to narrow the issues for her to the extent that I could. But at the same time, being aware that I don't represent Ms. Walker, I'm representing the defendant. So I told her that she should probably look into some of her claims with a little more diligence to see if she can narrow them. And that was the extent of the conversation, and letting her know that we need to get all of her claims that she has in 3 cause numbers into one, preferably by next week. That was the extent of the conversation that I had with Ms. Walker.
Okay. All right. So Ms. Walker, you guys will need to figure out how that consolidation happens, and if you could put it in one cause number. I don't know if it lives on one cause number, you have to get a new cause number, or there's one couple of cause numbers get tied up and live in, and one cause number survives. So anyways, go ahead and figure that out. I just need a date. When, first of all, when are you guys going to have set the date for mediation?
September
Yes, Your Honor,
7th.
we have it for.
Oh, sorry.
That's fine. Yeah, that is correct. September 7th at 1 p.m. Your Honor.
Okay, that's 7 September 22 at 1. Alrighty, and then number 2 is the date that we come back to go ahead and tell me that the consolidation and narrowing of issues has happened, claims and issues. When is that?
That's also maybe I'm confused, saying it a little different. I had picked for the 14th of September. Mr. Stricker was not in agreement with that. He felt that was too soon, and also said that his witness or client could not be there on any Wednesday.
Yes, Judge. Yes, as far as trial, I did confer with Ms. Walker on that subject. I also got in touch with my client this afternoon to check for the availability of one of my key witnesses. And funny enough, Monday mornings and Wednesday mornings are not good for my witness to attend a trial. So I can do really any other day and time except for those mornings on Monday and Wednesday. And we're set.
Well, let's talk about the trial next.
Okay.
Right now, I need just a date for me to follow up with you guys about the consolidation and narrowing of issues and claims. That does not need witnesses. That's you two coming back and telling me what we're going to go to trial on.
The 14th of September, Your Honor, if that's okay with you.
Well, yeah, Judge, I think Ms. Walker is thinking of the trial date still and not the consolidation of the claims.
No.
Is that what you're asking, Your Honor, about which date Ms. Walker has to consolidate her claims into one cause?
Right.
Yes.
And the issues and claims have been narrowed.
Yes.
I think she needs your cooperation of that.
Yeah,
Your
Honor.
I just want to make sure that you guys know and are ready to go to trial on a certain date, and there's no. You guys have, okay.
Yes, Your Honor, understood. Yeah, I mean, I think it makes the most sense for the court to be most efficient to have all this in one cause. As far as what that looks like, as far as what claims Ms. Walker wants to assert against the defendant, I have to leave that entirely up to her. I don't want to, persuade her either way about which claim she should and should not bring. But I think Ms. Walker should consolidate all of her claims into one cause before we move to trial.
Okay. All righty. Let's have and issues. All righty. So when is that going to happen?
Your Honor, I had already did it, consolidated it. So presenting that to the court or writing the motion and having it sent along with the consolidated paperwork is immediate. So I will be ready on the 7th of September and the 14th of September.
Okay.
If that's all right with you.
All righty. 14th September.
Yes, ma'am.
For that, and I'll just have one cause number by that time, right?
Yes, ma'am. Yes, ma'am. And I do want to apologize for that. I see when you showed me, I understand what happened now with that. So.
All right. So now we have Number 3, date for a trial. Okay, what I'm going to do at this time is I'm going to, what I have suggested Wednesday is that's the best date for me. If that's not going to go ahead and work for you guys, I'm going to put you in the breakout room with my court coordinator so she can help you guys figure that out, okay?
Yes, ma'am.
All righty.
Yes.
Anything further at this time, Ms. Walker?
Yes, Your Honor, I narrowed it down to just 5.
Ms. Walker, you can tell me all of that, and once I get the file, the
Oh, okay,
revised file, once you're going to go ahead and do that. But is there anything else today for this logistical review here?
No, ma'am.
We've got
That's it.
mediation date, we've got a consolidation date. Now we just need a trial date. Anything further?
No, ma'am. That's it. I appreciate your time.
No, Judge, that is all. Thank you. Appreciate your time.
Okay. All righty, so let's go ahead and get you, we're off record, get them in the room with Ms. Luna. And after that, you guys can, after you finish talking with my court coordinator, Ms. Luna, you're free to go, okay? Your excuse.
Yes, sir.
Thank you.
Thank you.
Thank you. Attorney Ornelas?
Yes, Your Honor.
Okay. What is your cause number, please?
The cause number is 2022 CV 01671, Your Honor.
I didn't grab that. Let me go ahead and call for that to be brought to me, okay? Your file. As a matter of fact, counsel, can I have you go ahead and call 210-335-2573?
Right now, Your Honor.
Right, let them know that it is a civil case and it's probably in my office. Have them bring that, give them the cause number and have them bring that to me, okay? And while you're doing that, I'll take care of another case, all righty?
Thank you, Your Honor.
Thank you. Cause, Ms. Kolonek? Am I saying that right?
Yes, ma'am. Yes, ma'am.
Oh, sorry, ma'am. I can't have you in a vehicle at all.
You hear me?
Yes, I cannot, yeah.
She pulled over. Yes, ma'am. We're sorry. I've been putting off work to do this, and I've got to get things done too. So we're stopped. We're stopped. We're stopped now.
Oh, I'll let you get to where you're going so you can be.
We're done. We're here, ma'am.
Well, then I need for you to get out of the vehicle and find a quiet place to participate.
Yes, of course. Okay, sorry, ma'am.
Sounding better. Okay. If you could stop moving. So at the time that I talked with you earlier, you were able to get a hold of the, let's get on record, okay?
Yes, ma'am.
You ready? Okay, let's go ahead and get on record on cause number 2022 CV 02455. And this matter is styled Marcelo Saldana versus Julia Crone, spelled Krone et al. Parties, please approach and identify who's before the court, starting with the plaintiff, Marcelo Saldana.
Helen Chronic, person for the plaintiff.
Who?
Helen
now?
Chronic.
Oh, okay. And you're saying you're present for the plaintiff, Marcelo Saldana. Are you an attorney?
No, ma'am, I'm not an attorney. I have a limited power of attorney from him.
Is that on file?
I'm not sure if it was filed on file, ma'am.
Okay. I'm going to go ahead, that limited power of attorney should be on file so that court will be able to ascertain that you have authority to act, okay?
Okay.
And what your powers are. Do you understand?
I'm sorry, didn't understand you.
I'll need to go ahead and get that on file.
Okay, can we reset for 1 week so that I can send that in?
Yes, ma'am, that would be fine. You want to come back when? Wednesday?
Next Thursday?
Wednesday.
I'm not available on Wednesday. I've had the courts scheduled.
I'm looking at either the 10th or the 17th.
The 17th.
Which are both Wednesdays. Those are both Wednesdays, ma'am.
Okay, the 17th. I'll be available on the 17th.
Okay, so on the 17th, I will have, that will give you sufficient time to provide and ensure that this court knows of your powers. And also we're discussing with the defendant, make sure that the defendant understands that they need to be here. Send them another notice, or we'll try to go ahead and send them a notice. Do you have contact information for them besides this phone number?
The address.
You have an address for them?
Yes, ma'am, I do.
You have an email for them?
No, she doesn't have email.
Okay, and the phone number, do you have a phone number?
The phone number for her is area code 210-430-5585.
And you have been able to reach her then at that phone number?
Yes, I spoke to her twice. You asked me to give her a call twice today, and I did. I spoke to her. And
okay. All right, please let her know that, thank you so much. That's the time that you're on Wednesday. What time would be best for you, 10 or 11?
Let me, 11 o'clock.
Between 10 and 11, 10, 10:30, 11, which one is better for you?
11 o'clock.
Okay, thank you, sir. Didn't hear you. All righty, we're reset. Thank you, ma'am. Anything
Thank
further?
you, ma'am. No, ma'am. Thank you. You have a good evening. Thank you.
You too.
Bye-bye.
Yeah. Damn it. Okay. Let me take care of a matter so that my deputy will be able to go ahead and take off here. Sir, please approach. Oh, okay, okay. You're Jason Matha? Alrighty, okay. Okay. Alrighty. I have your phone number, don't I, sir?
Yes, yeah, I think we have to.
Okay. Let me just get it real quick.
You know, combining criminal and civil, it's a lot of work, and you're doing an excellent job.
Thank you,
And
folks.
I'm not just saying that because of my case. I'm a community person, so I appreciate that.
Thank you.
God bless you.
You too. Thank you so much.
All right.
You too, sir. Okay. Attorney Ornelas, thank you so much for your patience. I've got your file now. It is, let us get on record on cause number 2022 CV 01671. This is a case styled Panther Springs plaintiff versus Stephen Coleman defendants. And parties, please approach and identify who's before the court, starting with the plaintiff.
Amanda Ornelas, Your Honor, for the plaintiff.
Stephen Coleman, Your Honor.
Okay. Counsel, please, as a plaintiff, please proceed. Why are we here?
Your Honor, this is an appeal from the Justice Court for an eviction. On February 25th, 2022, the Justice Court Precinct 3 of Bexar County awarded my client $3,585 in unpaid rent. Mr. Coleman appealed his eviction on March 1st, 2022 from the Justice Court. His rent amount is $1,195 per month. The eviction was filed on the basis of unpaid rent, which is now currently remains unpaid in the amount of $15,507.68, of which $11,950 is solely rent and does not include the month-to-month charges that he is contractually obligated to pay due to his holdover status. Mr. Coleman's lease term was from September 1st, 2020 to May 31st, 2021, and has now expired and has not been renewed. Additionally, Mr. Coleman has violated his lease by participating in obnoxious conduct and disturbing his neighbors and property management employees. This has resulted in the police making multiple visits to the property to address the situations. He has also refused to allow maintenance to enter the unit when he claims there are emergency maintenance issues to be addressed. He demands immediate attention, but then refuses to provide access in the event of these claimed emergencies. These lease violations, along with his non-payment of rent, are the basis for the non-renewal of his lease and the subsequent eviction. We are asking the court to dismiss Mr. Coleman's appeal and award plaintiff unpaid rent and possession of the premises located at 1658 Blanco Road, apartment 901, San Antonio, Texas, 78232, and award plaintiff costs of court. We are also asking the court to allow the clerk of court to issue a writ of possession after the expiration of 5 days from today's judgment. We're also asking for $2,680.72 in reasonable and necessary attorney's fees for my appearance in and preparation for multiple hearings, reviewing client documents, and documents sent by Mr. Coleman, along with correspondence from Mr. Coleman. Thank you, Your Honor.
If I understand, it's writ of possession, unpaid rent in the amount of how much?
In the amount of $15,507.68.
Okay, 2 seconds. I apologize, counsel. So that's writ of possession, unpaid rent that you're seeking, and how much?
And are you asking about the attorney's fees or the rent?
No, the rent. How much in unpaid rent that you're seeking?
$15,507.68.
And then attorney's fees is how much?
Attorney's fees is $2,680.72.
Okay, so those are the three things that you're seeking, or did you say court costs as well?
Court cost as well, Your Honor.
Okay. All right, so I have 4 things that you're seeking. Is that correct?
Yes, Your Honor.
Okay. Defense, Mr. Coleman?
Yes, Your Honor.
Proceed. Your response?
My response is, first of all, I've tried to get or retain Miss Yates early. However, she was not available today, which is the reason for the reset.
Oh, yeah, it's that I'm sorry, you should have addressed that, right? But you're having your chance now to address that. You said that you needed an attorney.
That is
And so
correct.
you-
She was not available today.
Mhm.
Additionally, the allegations
Mhm.
of criminal misconduct, I have all of the police reports minus one that I
Well,
was allowed to get through discovery.
Hang on 2
Each-
seconds, sir.
Yeah,
Hang on 2 seconds, okay. You had asked and requested the court to reset this matter and agreed to today for time to hire. You needed 2 weeks. We were here the
Yes.
22nd of July, okay? So that's the first thing that we need to go ahead and address. So now you're saying that you hired an attorney?
yes, I spoke with an attorney and she said that she was not available today. If I could get a
Sure.
reset,
So there's a difference between speaking to an attorney and hiring an attorney. So which one is it? What's the status of that? Did you hire her?
she agreed to take the case, but she wasn't available today.
Well, sir, as far as the days are concerned, that's something that you would have to go back to the plaintiff and say, can we reset it? Or have called the court earlier to say, can we reset it? This is the date that your attorney would be available. We could have reset it. I mean, the attorney's fees on the plaintiff's part is just going to continue mounting because here they've appeared again. But we could have reset this if you said, hey, I hired my attorney, but they're not available. And they could have, we could have reset it for when your attorney is going to be available.
And the lead counsel, Eric Pullen, was not available. He was out of office this entire week.
Got it. But you understand that if you had communicated this earlier with Attorney Ornelas, then
I did communicate that with Ms. Ornelas.
Oh,
If I may, Your Honor, he actually told me yesterday he was still having a hard time retaining counsel. And Mr. Pullen is with me on this case. We're both listed on the notice of appearance. I'm here, so it does not matter that Mr. Pullen is not here. We both work on all of the eviction files for this client.
yeah, I mean, you're the lead counsel that I've seen in this case, so. I thought Mr. Pullen was available, was an attorney on your side.
He is. I don't know why Mr.
No. Yeah, Mr. Coleman, whether Mr. Pullen is available or not, if he is on the plaintiff's side, that doesn't impact you, right? Because Attorney Ornelas is here representing. Do you understand?
Yes, I do. However, the automatic replies were that he was out of office this entire week.
Okay, well, that's him. But Attorney Ornelas has been the person that I've seen on this case.
I've
That's
also
who you
been
need to
communicating
believe.
with him all of today and all of yesterday. So he's been aware that we've been available for this date.
Not Attorney Ornelas, not a problem. So, Mr. Coleman, is that correct that you were in touch with Attorney Ornelas yesterday and you said that you're still having a hard time finding an attorney?
That is correct. That is the truth.
So who is this person? Yates?
Yates Early?
Yates Early.
Yep.
Who is this person?
She's a property eviction attorney.
Okay,
Landlord
sir.
tenant attorney.
Sure. Now, there's a couple of things that I've heard here, okay?
Okay.
One, you're saying that you've spoken with her, she's willing, okay, one. And that's not the same thing as hiring, but then you came back and you said she's She said she's willing to take the case. And then you say she's just not available today. And that's when I was telling you, hey, listen, communication with Attorney Ornelas, we could have reset this so it doesn't cost any more money on the plaintiff's part. So, but now you're telling me that, yes, you're still having a hard time finding an attorney. Which one is it?
For today, I am still having a tough time finding an attorney for today. And I spoke with Ms. Ornelas yesterday after receiving the out of office replies from Mr. Poland, because the law firm sent me a notice saying, do not contact Ms. Ornelas.
Mr. Coleman, do you understand that this is piling up attorney's fees for the plaintiff? It's costing attorney's fees. Do you understand that?
Yes, and I mean, that's through no fault
sir.
of my
Do you
own.
understand? Yes, it is. Yes, sir. I'm sorry at this time because they have come here. Okay. I just wanted to let you know that it is, and it's just going to impact you because if they're successful, that adds to your fees, what they wish to collect from you. That's what I just want you to understand. They're asking for attorney's fees. So they're going to bill today. Okay. And they're going to ask, hey, court, can you go ahead and add today's bill to what we've already compiled? You're looking at.
And additionally, Your Honor, prior to 2 weeks ago, I had made an offer that was very similar to the offer to resolve the situation, but it fell upon obstinate ears.
Sir, the thing about it is I need to hear about your we need to resolve your representation. So I need for you to be very clear with me. Help me to understand where you stand with representation so that I may be able to make a decision that is fair to both sides. Okay? Please make me understand clearly where you stand with representation.
Miss Yates Early was not available this Friday. However, she would be willing to take the case.
Okay. Do you have a letter of representation? Do you have that in writing?
No, ma'am, I do not.
Okay. Alrighty. Now, when do you think that you can get that in writing and a letter of representation sent to this court?
I don't know how long that would take Miss Yates Early to provide, but again, I paid into the registry for the month of August.
Mr. Coleman,
Yes.
I need for you to understand, I need to make a decision based on representation. I've given you 2 weeks to have an attorney here. Now you're saying that attorney wasn't available today. Availability of an attorney is as quickly as you can make an appointment. So you's telling me that she's willing to take the case. Do you have an appointment with her? Have you met with her?
I have met with her.
Huh?
I have met with her, yes.
Okay. Do you have a contract with her?
No, not yet.
If you have met with her and she says she's willing to take the case, what is the holdup?
her availability of today.
No, sir. No. Availability today is not an issue. We can work on that. But I need for her to be able to send a letter of representation that she is on your case. When can I get that?
Within a week?
I can give you till Wednesday.
Okay.
Wednesday, on or before 12 noon, Wednesday, the 10th, I need to have Miss, what did you say her name was, please?
Yates Early, Y-A-T-E-S.
Okay.
Y-A-T-E-S dash E-A-R-L-Y.
Okay. Is that a hyphenated last name?
Yes, Your Honor.
Okay, what's her first name?
I want to say Gloria.
Okay. All righty. Okay. This is what's going to happen. Attorney Ornelas, I beg your patience. This is what's going to happen, Mr. Coleman.
Mhm.
By 12 noon, no later than 12 noon, Wednesday, the 10th of August, I need a letter of representation. Okay. Notice of appearance, letter of representation of Miss Gloria Yates Early filed on this case.
Okay.
It has to be, she knows how to do it. She know how to do it. Electronically filed, and you give them Miss Attorney Ornelas' information, and so that she can contact and make sure that Attorney Ornelas knows how to contact her, okay?
Okay.
Alrighty. So if not, you return and you tell me that, oh, I don't have an attorney. You need to come back on Wednesday by 2 o'clock and tell me, hey, I don't have an attorney. Or by then 12 noon. That 12 noon will be fine, okay?
Okay.
And then you I need for you to communicate that in writing to Attorney Ornelas. You have her direct contact information?
Yes, I have her email address.
Okay. For Attorney Ornelas.
That is correct, as well as Mr. Poland.
I need for you to send it directly to Attorney Ornelas, okay?
Yes, Your Honor.
If by 12 noon, that has not been filed, I need for you to, between now and Wednesday, the 10th of August, you are going to email Attorney Ornelas that you do not have an attorney. And you want to go ahead and set up another court date to finalize this. If you have an attorney between now and the 10th of 12 noon, the 10th of August, she will file a letter of representation, and she will contact Attorney Ornelas to say, hey, this is when we need to reset this case for. Is that clear to you?
Understood, Your Honor.
Okay. So our turn between now and 12 noon on the 10th, Wednesday, the 10th of August, Attorney Ornelas is going to have email communication from you or your attorney.
Yes, Your Honor.
And if it is your attorney, a letter of representation will have been filed with the court.
Understood.
Do you understand? Okay. Attorney Ornelas, any questions?
No questions, Your Honor, but I would like you to know for the record that this is the first time ever he has mentioned an attorney, even though I've asked him yesterday if he has found an attorney, and if he has, to have them please contact me, because Mr. Coleman has been unable to speak to anyone at this office in a professional manner.
And for that, I wish for it to be in writing that he communicates with you.
Thank you, Your Honor.
Okay. So, Mr. Coleman, I am here to clarify any misunderstanding that you have of the court's order.
No, Your Honor.
You got it. Okay. So.
Understood.
Okay. Very good. No questions, Attorney Ornelas?
No, Your Honor.
Okay. Alrighty. So on the 10th of August, that afternoon, Attorney Ornelas, I need communication when this matter is going to be reset. Contact my court coordinator, please. You've spoken with her. And let's go ahead and get this matter reset for the final time.
Thank you, Your Honor. We will do
For
that.
It will be for disposition.
Thank you, Your Honor.
Okay. Mr. Coleman, what
Yes, Your Honor.
I have, I just want to make sure that there's no misunderstanding. 12 noon, Attorney Ornelas is going to get a communication from you or from your attorney.
Yes.
Okay. And then by the end of the day, by 5 o'clock of the 10th, she is going to communicate a reset date for disposition of this case.
Okay.
She will
Okay.
have that CC'd you. She will communicate that to you or to your attorney. Okay.
Understood. Understood.
Alrighty.
Yeah.
Okay. And if it's with the attorney, please do a Rule 11. Attorney Ornelas?
I'm sorry, Your Honor, could you repeat that?
Right, if it's with the attorney, please do a Rule 11.
Yes, Your Honor.
Go ahead and file that, and then send that by email so that we'll know when that is going to be finalized.
Will that be your email, Your Honor?
Yes, you can communicate with my court coordinator. Okay. Because you between 12 noon and 5 o'clock, you guys will need to contact Miss Luna to figure out a date.
Yes, Your Honor.
Yeah, okay. Again, Wednesdays will be best. Okay, so.
Noted. Thank you, Your Honor.
All righty. Any questions at all, Mr. Coleman?
No, Your Honor.
Okay, so next time I see you,
Yes.
I need for you to understand this case will be over and done with.
Okay.
All right. Okay.
Yes.
All right.
Thank you.
Okay. Attorney Ornelas, okay?
Yes, that's all from us, Your Honor.
All righty. Thank you.
Thank you,
If
Your Honor.
nothing else, but you're excused, and I look forward to hearing from you next week.
Thank you, Your Honor. Have a nice weekend.
You too. Thank you. Oh, I still need to talk to you.
Oh, do you want me to call right now?
Yes, yes, I think so. This would be a good time. Thanks.
Okay, thank you.
Uh-huh.